My lord, my case number
with retrospective effect, my lord, in the relating to covered by Delhi Court Barpoda, my lord, that Supreme Court will confirm, my lord. I will actually pass the order.
Supreme Court not confirmed on delay ground that has been.
No, my lord, the tribunal has passed the order.
Anyway, order of the our representation come final now.
Yes,
In the light of that, they have to consider. We have passed a similar order.
My lord.
Again, they are for consideration only.
Page 49.
This one. Next, item 2.
This is the second round of litigation, my lord. Earlier, your lordship has directed to consider my representation.
Use mic. I have some cold and therefore I am not in a position to hear also.
Earlier, your lordship has directed to consider my representation, but they have rejected. That is at annexure 11, page 47.
Link subscriptions. Next, item 3.
my matter is,
May I please,
my lord.
Yeah.
my limited grievances, my lord. Before the BNC, whatever they have wanted, all documents have been submitted. After receive the same, again they have issued letter by the annexure 2, page 64. Submitted documents, my lord. I have already submitted annexure 1, my lord. All documents.
Yes.
Only direction will given, my lord. They have accepted my documents, my lord.
Whatever documents have been already given,
Yes, my lord.
those documents you should consider, and if they are worthy, you have to accept it. Again and again asking them to why they should.
BDA, my lord. BDA note.
Yes, OP number 3,
OP number 3.
my lord.
Issue emergent notice. Mr. Lenka for 1. Emergent notice to the rest. Returnable within 2 weeks. Since matter lies in a narrow compass. Okay. Item 4.
Grant of pension, my pension and
My lord,
pension.
notice by registry post.
Whichever way you want.
Registry post.
All
Only, sorry, speed post.
Speed post. Register post is not there.
Yes, sir.
Yeah.
Speed post.
Yeah. Item 4.
May please, that is the release of pension and pensionary benefit, my lord. That is petitioner.
She is relying a judgment which is under subjudice the writ appeal, my lord. That is Hemanta Kumar Chutra.
Correct. But there is no stay in that. Therefore, in other wherever there is no stay,
Outcome of the
subject to that only. Do we have made such orders now? Do you have any order where we have made
Similar
that?
matter, lordship notice, issue notice, my lord.
No question of notice now. I will direct them, you accept notice and where is your representation?
no repetition.
No representation. That is,
He has not filed any repetition.
No, in terms of this judgment,
my lord.
grievance is for non-sanctioning of pension.
My lord.
For that, you have to make a representation in terms of this judgment. That they will consider in a reasonable time, but it will be subject to outcome of the writ appeal.
Well, file
That
fresh,
order I have passed in rest of the matters.
file fresh representation.
All right.
My lord.
The short grievance in all these matters is as to non-sanctioning and releasing of terminal benefits, including pension, etc. First, Learned counsel for the petitioner heavily presses into service the decision of a coordinate bench of this board
Annexure 5G.
at the result fight full right that the Hemant Kumar Choudhary versus so and so. First, she submits that pension being not a bounty in the light of Devaki Nandana Mishra versus State of Bihar, followed by DS Nakara versus Union of India, any delay on the part of erring officials has to be met with strict action. First off. Next paragraph. Learned AGA, Mr. Lenka, on request appearing for the OPs, opposes the petition, contending that in the absence of demand and rejection, ordinarily the writ petitions are not maintainable. First off, having so contended, now he agrees that if an appropriate representation is given, supported by all relevant material evidence, there would be no difficulty for considering the same in accordance with law. First of all, he also points out that the decision which has been pressed into service by learned counsel appearing for the petitioner has put in challenge in writ appeal before the division bench, and therefore there would be some difficulty. First of all, this I do not agree, inasmuch as there is no interim order in the said decision. First of all, I did whatever order to be passed on the representation in the in contemplation would be subject to outcome of the writ appeal, and that would take care of interest of every person. Next, in the above circumstances, petition is disposed of, reserving liberty to the petitioners to make appropriate representation within 2 weeks, and if one is made, decision to be taken thereon in the light of the coordinate bench decision within 4 weeks next following, failing which, on an application being moved, heavy costs may be levied on the jurisdictional authorities, payable personally by them. First of all contentions are kept also. Now no costs. Next.
Item 5.
My lord, can you see my prayer portion, my lord? Page 10, my lord. Page 10.
Same.
Page 10, no, my lord.
Pay scale.
Page 10, my lord. My prayer, my lord.
There.
There.
Covered by judgment.
No, my lord.
We had made one order in similar matters. Now you take notice, Mr. Lanka?
Yes, sir.
Yes. Lanka accepts. Emergent notice to fifth one.
All.
All. You will take notice for all.
Yes. Yes, sir.
Item 6.
Similar matters, my lord, already judgment passes, coordinate bench. My lord. This is
Do you have copy?
my lord.
Therefore, I asked you.
Management understood. So understanding that.
Yes, Mr. Lanka. In Manoj Kumar Jaina's matter, we have already, the court has already passed order, no? Justice Shashikant Mishra Saab's judgment.
Yes, sir.
In the light of this, you consider the prayer.
Letter 5, represented, sir.
Representation is there, perhaps already.
My lord,
22 of the year 22.
Of the year 22.
The fresh representation of that.
Petition prayer reads as under. First of all, learned counsel for the petitioner vehemently argues that in Manoj Kumar Jaina versus State of Odisha, WP number 7944 of 2018, decided by a coordinate bench of this court by order dated 13/9/2022, relief has already been granted, and therefore, our client being similarly circumstanced, same relief needs to be extended. First of all, next paragraph. Learned counsel for the AGA for the OPs opposes the petition, contending that if a representation is given, there would be no difficulty for considering the same in the light of the observations of the coordinate bench in Manoj Kumar Jaina Sukta. First law. With this proposal, counsel for the petitioner is agreeable. In the above circumstances, petition is disposed of. Similar or last within 2 weeks. That it is. Next.
Item 6.
May I please, your lordship? Lordship, praying for an adjournment. Praying for an adjournment to file, to amend the petition to file some vital document we have not filed, lordship.
You withdraw this petition and file a comprehensive petition. I give liberty to you.
Hon'Ble.
All right. Counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to file a fresh one, along with all necessary pleadings and documents. First off, he has offered a plausible explanation as to why he could not do it in the present petition. First off, in the above circumstances, petition is disposed of, reserving liberty to the petitioner as sought for.
Obliged. Item 7.
May I please, your lordship? Initially, a writ application was filed to challenge the action of the opposite parties to a not filling of the post in non-government fully aided high school. But subsequently, the
Similar matters we have posted them with 2 weeks a day.
Yes, sir.
Well,
They have
16
given data and other things, na? How many cases
January.
vacancies are remaining?
16th January.
Ah.
16th January.
Huh?
16th January.
16th January?
Yes.
Yes.
All right. Issue emergent notice. Mr. Lenka accepts notice for one panel council Sri for a selection board, na? State selection
Yes.
board.
Yes, ma'am.
Who is a panel council?
Mr. Patnaik and Mr. Swain.
Issue emergent notice to call this matter along with on 16 January. Okay.
Well, if the Honorable Court permits, Mr. Swai appears for the OP number 2. Mr. Swai, Sanjeev.
Signed, so appears for signing. So petitioner to serve a copy of the petition along with all the documents on the panel council right now. Next.
Grateful, my lord.
Item 8.
Ah.
Item 8, my lord, one pass over.
One pass over.
After long.
Pass over.
Item 9.
Yes.
Here are limited theories to construct the Bhagavad Trumi building in some other place of the village instead of river embankment. River embankment will be affected. That is our sole grievance, my lord. They have made a representation before the collector. That's what.
You consider the representative.
Yes. And it's a three series.
Short prayer of the petitioner reads as under. First, petition is preceded by a representation dated. What is that date? I do not.
Dated, my lord, 12/11/2020.
12, but both they look the same only.
No, that is the collector Jajpur, page 14.
12/11.
Page 14.
Yes, 72.
14, man.
14.
1-4.
Ah. Dated 12/11/20.
12/11.
At the next
Three series, my lord.
so which reads as under. Which reads in the next. Mr. Lenka opposes the petition contending that where construction should be done is a matter of executive wisdom and therefore citizen cannot have a say in the matter. First, having so said, he agrees to inspect OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law if all contentions are kept open. With this proposal, counsel for the petitioner is agreeable. Next paragraph. The above counsel petition is disposed of. Next.
Item 10.
Miller, small prayer. Till then, no construction.
No.
What 10 minutes from the appearance for cabinet absorbing copy in course of the day. Let it be day up to 2 months.
No, day after
Tomorrow.
next week.
Yeah, tomorrow.
No, yeah, because my lord, that is, it's my lord, that is 63 pages. Next week, next Monday, my lord. Next Monday.
Next.
Against the final order passed.
Let us.
Item 11.
In this case, petitioner is continuing as a 10 graduate teacher in ST and SC Development Department, school, my lord. Now, under annexure 4, my lord, it was promoted to the post of 10 graduate teacher, my lord. Annexure 4, page 17, my lord. But here, what happened, my lord? In the meantime, my lord, under annexure 7, 6 and 7, the government of Orissa.
Yes.
Let him take notice.
But what happened? They are now giving promotion to the post of postgraduate teacher, my lord. But with the there is no absolutely there is a rule, my lord. The persons those are continuing in the high school, my lord, having being a 10 graduate teacher, equivalent to the 10 graduate teacher continuing in ashram school, my lord. But they have stated in the circular, my lord, that the person those are continuing in only high school 3 years
Will be considered.
they will be considered, my lord. Lords, you kindly see annexure 7, page 22, my lord. 6, my lord, page 20. Lords, in the middle part, my information about 10 graduate teachers for consideration to post of postgraduate teacher.
20.
Page 20, my lord.
Information of trained.
My lord. Here, my lord, the middle part, completed 3 years of regular service at TGT in ST-SC Development Department high schools, my lord. They are
Yes, sir.
included.
Mr. Lenka, how can that be done?
I
Grossly
take,
discriminate.
I take instruct, my lord.
Then they don't give effect to this.
No, my lord.
See, Rajasthan Electricity Board versus Mohan Law, very old judgment. You can't that way discriminate at all. Issue emergent notice. Definitely, is to encourage request to accept notice for the petitioner.
Any promotion is subject to your lordship.
No, not that. Otherwise, we will go on doing all those deeds. Till an application is moved within an order of reprieve. First off, it is supported by an affidavit. First off, the Met Council has made up a prima facie case for issuance of some reprieve so that the clients are not put to prejudice. First off. In the above circumstances, application having been favored, the impugned, what is this?
Lecture 7, my lord.
Dated 28 January 2025 between joint director and between the joint directors at Annex 6 is kept in suspended animation till next date of hearing.
Lecture 6 and 7, my lord.
6 and 7?
6 and 7.
The 6 and 7 are kept under suspended animation. Okay. Till next date of hearing. Yes.
Your lordship may only annex 7, your lordship may.
6 and
6
6.
also. 6 is facilitative.
Yes, sir.
7 is effective.
My lord.
Therefore, both we have kept in, yes.
Content of
Yeah.
Item 12.
Yes.
Lordship is the RSP matter covered by Ashok Mahapatra. The Lordship first.
Will we change the factors?
Yes.
Next.
Item 13.
Item 8, Passover, he has come, my lord.
Yeah. Yeah.
Sir, my lord, this is a termination arrange.
Louder.
Sir, my lord, this is a termination arrange. This is a my lord, this is a termination arising out of FOSO complaint, which is filed after 7 months of the allies chart. And in the violation of the section 9 POSO, the internal committee prejudged it's guilty and direct applies even before the inquiry, and the same preceding officials, both the author, the report and the rejection and the objection, making the entire proceedings void. The punishment of the termination is seeking disappropriate for a consulence for a WhatsApp conversation only single line, whereas the ICC admitted that the complainant 40,000 rupees monetary demand was a friendship talk. But a single line of WhatsApp chat makes a sexual harassment and at workplace. For that reason, the ICC covered for the termination, immediate termination for the 12 years without any allegation, without any issues. And the person served at Secretariat with a contractual job.
Internal committee report.
Sir, the internal committee report was there. Annexure
4, my lord.
4, my lord.
What the committee report said?
82, page 82, fact finding. And 83, observations.
The complete summary also we give a representation completely on the same ground, but rather than going through that, the committee decided give a decision for the rejection, where the complainant asking for a applies letter, but instead of that, give a termination on the same. Which is already filed. The chart happened, a single line chart happened in the 7 months back, and they filed a 1cc internal committee. They filed a case after 7 months. My lord, we are requesting for an interim stay, at least because the petitioner is working from last 12 years, and the 12-year career is married, and 8 years or 8-year-old son has been there. There is a lot of issues will come up into a stage. Sir. Apologies, sir.
He was engaged as a legal consultant.
There is no discussion or there is no communication between the work hour. It is completely the petitioner was at Thailand and the communication happened from the complainant side at night 11 o'clock. Mayan. There is no unwelcome elements are seen.
Brother Lenka. Except that asking question about her menstrual period, etc., it is wrong. Nina Gupta. But where are the elements of sexual harassment? Those other questions he should not have asked is another thing. Anybody will understand that. No sensible person will ask such questions because of Nina Gupta versus LICR, which is that judgment, which say the privacy questions relating to these are things should not be asked. Which is that? Can you Google out that judgment? Nina Gupta versus so-and-so, so-and-so. Except that, where are the elements of sexual harassment?
Lakshmi kindly.
Which is that judgment?
That is.
My lordship, there is the both people are from background from the ex-army and residing at Cuttack in only sir.
Them belong
Bihar.
Sir, both people are side to side house is there. And all the chats, sir.
Yes, sir, Mr. Lenka.
I think that is the Haryana case, 96-1 SCC.
96-1 SCC, 1 SCR.
It is 753.
753. Those questions he should not have asked, that I can understand. But how that will take him to the precincts of this act?
That for that.
And lady has asked for money also. That lady has asked for money also. Many times, after the checkpoints happens, case goes to the sexual harassment.
Both of them were engaged as legal consultant. One lady is the assistant legal consultant, now at present working before your lordship's court. So what I suggest, if your lordship put it in a camera proceeding, it will be better.
In camera proceeding?
Yes. And I will take instruction.
Appears to be said.
Yes.
Sir, till that may take any precipitate reaction.
No, already he was engaged as a legal consultant. He has been disengaged. Yes.
When?
Nonsense.
Not at all registered, sir.
So she pays 64. Recommendation about that. There is no defined service conditions for them. No defined service conditions.
My lordship is in contractual and working from last 12 years.
In higher education department,
still working?
Sir, still working?
No.
She is still working.
Still working, sir.
I know this matter.
Well, sir,
certain intelligence.
Yes, your lordship may record his submission that he is still working.
still he is working and going to office.
You are making submission on the instruction of your client.
No, sir.
Wait, let us see. We'll call this matter tomorrow.
Yes.
If he is still working, then may not be. And he has offered apology also.
In his representation, he has denied. He is not working. Anyhow, you lordship.
But there is not a case of sexual harassment.
That's all.
Maybe he was little rough, tough, and not sensible by dealing with women. That's another thing. Yes. Call tomorrow at the request of the Lanka who wants to have conference with his flights, official place. Yes.
Item 13.
Madam, the petitioner is a trained graduate teacher continuing since 1992, my lord. His grievance is that, my lord, although he has been treated as senior and in the earlier gradation list 2023, my lord, he was placed above in the list, my lord. But and that list, my lord, has already been implemented by giving promotion by the annexure 4, my lord, to other persons, my lord.
Final list is published now.
Published by the annexure 3, my lord.
I'm asking published, final list published on?
Final list published, my lord, on 29/10/2025, my lord.
29/10/25.
25, my lord.
Where do you figure?
That my figure, my lord, has not been supplied. The list has not been supplied. But in 2023, my lord, the gradation list was prepared, my lord, wherein my name was fine place, my lord, at serial number 75, and the serial number of opposite partner 4 to 7 is at 80, 86, 89, and 90, my lord. But in the my lord, I am senior, my lord. But in annexure 5, my lord, the letter, my lord, which has been issued by the district education officer, my lord, page 17, my lord. Then my name, my lord, page 19, serial number 35, my lord. But whereas the opposite partner 4 to 7, my lord, they have been placed at serial number 21, 25, 27, and 28.
In?
My lord?
They are placed in what?
In the list, my lord. In the list, my lord. Yeah, prepared, my lord.
Dated?
Dated 15/11/2025, my lord.
You said 29/10/25.
My lord.
Now all of a sudden you are saying 15/11/25.
15/11/25, my lord, annexure 5, my lord, the letter which has been issued by the district education officer at Jajpur, my lord, directing all the headmasters to supply all the documents, CCR and proper statement and documented original service book for the purpose of promotion to the post of headmaster, my lord.
They are being considered for promotion.
Promotion, my lord.
You are not being considered.
Not considered, my lord.
To take notice, Mr. Ray.
Lordship.
Yes. Learned ASC, Mr. Ray is requested to accept notice for official notice 1 to 3, emergent notice to the rest.
Item 14.
My lord, annexure 5, my lord, may not be given effect to, my lord.
Yeah?
Because if others will be promoted, my lord, I will be highly prejudiced.
Any promotion will be, any selection and promotion shall be subject to outcome of
Pursuant to annexure 5, my lord.
Okay.
Item 14.
Well, this is a matter where in 1976, there was a gift deed by the then Jamidar of the Padampur to the government to have a hospital in his campus. That is totally gift deed, that land, my lord. Annexure 2 with only 2 grounds, page 16. My lord, kindly see.
How you are concerned with this land?
Because he is my father. I am the son of the who was gifted.
You are
The son,
the donor.
donor, my lord. And what happened in the meantime, the hospital will be named in the name of your wife. That is the only one condition. And you and your family will be given free treatment at the sub-divisional hospital. It is a government hospital. But recently, his wife died without being attended by the doctors because of internal bleeding. Now what they did, my lord, kindly see that Annexure 3, page 15. That is Sarla Kumari Sub-Divisional Hospital, Padampur. That was there earlier. But now what they did, they have just erased the name of Sarla Kumari, only government hospital. That is the only case.
Why, brother?
And they have also rejected.
Who will come forward to give land if you do like this?
Lordship,
You have given land.
Lordship.
Or with a particular, to commemorate a particular person. And after taking the land, if you remove that, tomorrow who will come forward? It's a serious consequence. Though it looks very, very, this one, it's a kind of onerous gift. Onerous gift is treated in Indian Transfer of Property Act. Mullah treats it. Where gift is conditioned. That condition need not affect the enjoyment of the gifted property. But where it is onerous, that onerous condition you have to comply with. You take notice. Matter lies in a narrow compass, call in the second week of January. Okay. Or you will consider the representation.
They were
Let's say they
rejected.
are rejected.
Rejected.
And it's to page 20, my lord, the regions they have taken.
Why rejected?
Page 20, my lord.
Which section of the Transfer of Property Act deals with onerous gifts?
Sorry.
Next.
Item 15. Rejection of claim of the petitioner for regulation of service. Annex 9, start from page 44.
Now it is rejected.
Yes. Annex 2, page 19. Since 1990, I'm working with the college as watchman. Subsequently, I've been.
All right, take notice. Yes.
Item 16.
My appeal, Your Lords. Here the petitioner is a PT, my Lord. He has been working since 1998 in the establishment of OP number 4, but he faced with a vigilance case because during his service career, he opted for contesting a panchayat election. He got actually with permission of the president and secretary of the school, he contested and succeeded. Now that period is over. Vigilance case has been initiated on the pretext that I have manipulated the attendance register. Till date, no inquiry, nothing. But they have stopped my salary and block rent.
Take notice.
The vigilance department has not made as a party, my lord.
Yes, business party.
What grievance he has got against the vigilance department?
My grievance.
He is acting on the premise that vigilance department is doing something. He says vigilance department is not doing anything to me.
During that period,
you are certain whether it is true or not. Yes, Mr. Sen accepts notice for both matter lies in a narrow compass, call in the second week of January. Yes.
My salary may be released. Last 6 years, I'm not.
No, you are a politician. You should not have gone to school at all, according to me. Yes.
Yeah, I'm not gone. In fact, I'm not.
Why you contested election?
With permission of the president, secretary.
You have contested election means you are well off. Yes, next.
Item 17.
The teacher was working since 1996, admitted facts. And he was transferred from one school to another school. And also straight to come to Annexure 9. It also need not go to the other thing. These are the admitted facts. On 30/12/2023, let's get it, Annexure 9, page 28.
30/12/2023.
I'm reading that. That is the government order. District Education Officer, in pursuant to the letter dated so-and-so of the School and Mass Education Department and response to the letter dated so-and-so of the Director of Secondary Education and consequent upon withdrawal of the resolution dated 1/2012, the ex-ULB employees transferred to School and Mass Education Department with effect from 28/2024 are hereby allowed the benefit of ORSP rules 1998 with effect from 1/1/96 notionally and financial benefit with effect from 1/1/2006 as per the resolution dated 2011/2010. Accordingly, the pay of petitioner, Prabhati Kumar so-and-so High School fixed earlier is hereby recasted as follows. You also look to the fourth column. From date of next increment is 1/3/96. Plus you get it. So,
1/3/96.
Yes, sir. Then, sir, kindly come to the transfer to School and Mass Education Department. That is in 2024, according to their own admission, from 28/2/2024. 2004. And accordingly, the benefit was extended, increment with a personal benefit increment was extended from 1/96, and actual benefit was given from 2006. Now, you know, kindly see, I think it's the Russia delivered a judgment in the meantime. Without notice, nothing. The benefit was allowed. But the impugned order was passed, Annexure 12 at page 33. Nothing. No notice, nothing. Pursuant to the letter dated of the Director of so-and-so, the pay fixed earlier in favor of Prabhati Kumari so-and-so petitioner, inadvertently from 1/1/96 under different ORSP rules, by order dated 30/12/2023 hereby cancelled. Accordingly, the pay fixed of third.
This was given to
that judgment you also have delivered. That is one.
Not necessarily. No notice was issued.
I am taking, sir.
No, just answer from the record.
From the record, it is not appears, my lord.
Where have you taken up that contention?
Sir, I have taken no notice, nothing. Specifically, I said.
Only from after the salary slip we could know.
Show that.
Yes, sir. That while the petition was continuing, paragraph 14, page 7. While the petition was continuing as such, when the petitioner received her salary from the month of October 2025, she was surprised that salary it was credited to her account instead of 63,420. The copy of the receipt. That on inquiry, it was found that salary of the petitioner was deducted based on the office order dated so-and-so.
No.
Improved.
My question is very specific. You are not.
Yes, paragraph 16. That the impugn order fixing, recasting the pay of the petitioner instead of 1196 is illegal, arbitrary, not sustainable law. And before issuance of such impugn order dated, no so cause or any principle of natural justice has been followed. Moreover, no reason has been assigned. Issue not judgment. Yes,
Emergent notice.
recovery is
Heard learned senior advocate filed. So issue emergent notice. This way the requested subnotice for office. An application. IA is more?
yes.
An application in IA number showing so supported by an affidavit seeking pay of impugned action solely on the ground that no opportunity of hearing was given before making that order. First up, such a contention is taken up in para 16 of the petition, which is loudly read also. First up. The principles of natural justice partake the character of Article 14 and 16 of the Constitution of India in this particular case. First, courts have gone to the extent of saying that an order passed in violation of principles of natural justice can be termed as ab initio void also. First up, the impugned order has financial implications. First up. Next up, in the above circumstances, application having been favored, the impugned order is stayed during the pendency of the petition.
On Annexure 12.
At Annexure 12. Yeah. It is open to the other side to seek variation of this order if grounds do exist in the form. Yeah. Item 18.
Item 18 may please, my lord. My lord, the petitioner's prayer is for appointment in the post of Sikhyasag against backlog vacancy. Your lordship has issued notice on 18/11/2025 in a writ petition that is to be tagged with that.
Issue notice all along it. The 19th.
Here petitioner joined as a Shiksha Sahayaka in contractual basis, and thereafter he has been regularized after 6 years and as a primary teacher. And after serving for 12 years, they said that he has submitted a fake certificate, +2 certificate at the time of appointment, and without following the OCA-CCA rules, Rule 15, regarding the memo of charge, no inquiry officer. They have terminated the service of the petitioner since 2022. And this honorable
2022.
Yes.
Why you are here now? Very poor. Everybody is poor in this country, especially in this state. Where have you taken up the contention, explaining the delay? Lavish pleadings, lavish arguments. You amend the petition. I'll give you time to.
And he is medically treated and medical documents are there.
That makes no sense unless pleadings are made. Call after 2 weeks to enable counsel for the petitioner to amend the petition for explaining the delay, long delay proved in approaching court. Since counsel is saying all irrelevant things for the system. Item 20.
Early disposal of execution case pending before the tribunal. Similar order, I have corrected it. Execution case is pending since 2020.
Same order.
Same.
Item 21.
Also, the petitioner is working as library watchman come bearer. His service has not been regularized. Annexure 5 is pending before the months.
Petition there is agenda. for the petitioner draws attention of the court to the representation dated 22/6/2025 at Annex 5, wherein the last paragraph reads as on. First one, counsel submits that if a direction is issued to consider the subject representation in accordance with law in a time-bound way, is client to be satisfied. First one, next paragraph. With the above stand of the petitioner, within the panel, the DGM, Mr. Mohanty is also agreeable, provided that all contentions are kept open. First one, this is the fair thing to happen. Next paragraph, in the above circumstances, this board of all weeks open to solicit. Yes. Item 22.
Item 22 minutes. C minutes. I'm a work contractor. I have executed work prior to time. I'm entitled to bonus. There is a clause in my agreement which says I'm entitled to bonus.
Work is done prior to the expiry of the period,
Yes.
given period.
Yes.
You are entitled to
Bonus.
bonus.
Yes.
If it is above malice, that way it operates.
Yes, damage. I'll have to pay. Now let's see that clause is at page number.
When the work was to be done,
Plus the work was to be completed by 18/6/2025. Now I have completed the work on 31/12/2024. There's almost 6 months prior to the designated date.
you should be given Nobel Prize actually. Generally, contractors do not do the job in time at all. You consider, you take that.
Now this issue is also settled by the Hon'Ble High Court. Our High Court, single bench, division bench, all decided in my favor. Judgments are there, Milord.
Work completion certificate is also issued now.
Yes, Milord. So work completion, my deviation, Milord, not only work completion. I have also executed certain additional work of 1,60,00,000 within that period.
This is a question of incentive and bonus completion of the work prior to the scheduled period.
Is settled. Yes. Where is your representation?
Annexure 4, Milords.
This is at page 114.
That may be decided, Milords, within a period. That will be settled to the sufficient. Let's see what they have said, because they have not said anything as of now.
The grievance of the petitioner has been aired in the representation dated 19/8/2025 at Annexure 4 or 9 it is.
Yes, Milords.
Annexure
4, Milords.
Annexure 4, which reads as next paragraph. Learned counsel appearing for the petitioner vehemently argues that law has been well settled by now, to the effect that when works contract is accomplished within before the cutoff date, the contractor is entitled to bonus and semicolon. The cutoff date for accomplishment of the work was 18/6/2025, whereas his client has done it on 31/12/2024 itself. That being the position, whatever bonus and other benefits which his client had is entitled to, ought to have been extended to him without without driving him to court. First, he also points out that he has done additional works worth more than 1 crore. But in that respect, money is paid.
No, that is also, I'll get bonus. Nothing has been paid. Only that money has been paid, but the bonus with respect to that are not been paid.
All done, and that this amount is also paid. First off, however, essentially, what is payable by way of bonus has been withheld for no reason whatsoever. First off. Next paragraph. Learned DGA Mr. Mohanty appearing for the OPs very fairly submits that although some disputed facts are involved, he would instruct OP number, chief engineer.
The superintendent engineer, he is my contract signing authority.
You put one officer higher.
Chief
OP
engineer.
numbers 4 and 5.
Yes, Milords.
By to look into the grievance of the petitioner in a time-bound way if all contentions of the parties are kept open. First off, with this proposal, counsel for the petitioner is agreeable. First, in the above circumstances, within 6 weeks.
Much. That's my only bonus is mentioned. That means a slash incentive. Incentive they are using.
Slash incentive.
Much of this.
Item 23. Item 23.
And on sentence, so delay will be viewed very seriously. Okay.
Your Lordship, over by your Lordship's order, with regard to RSP and it will make a repetition in portions with the Annex or 7. The coordinated bench
order.
Prayer column has to be different.
No, same. Same. All are same.
Okay.
Item 24.
May it please, your lordship. My lord, here the grievance of the petitioner is, my lord, that he is a charitable trust engaged primarily in protection of cows and stray animals and cattle. So in 2023, he was given the license by the RNC to operate within the Raulkala municipality area. And he did that to all satisfaction, pursuant to which another tender was floated in 24. He was successful and work order was issued for 2 years.
What is the outstanding amount?
Now, my lord, it stands as on date is almost 79 lakhs 18,000 excluding November.
Demand is made, representation is made.
Yes, my lord. That is annexure. Time and again I have been doing this. Last is the annexure 9, page 61. Now there are about 349 livestock there. They are not releasing any money, and it is out of my own funds I have been doing.
In house.
Yes. The work is to get the abandoned cows from the streets and the.
All streets I am seeing, all the cows are on the street only.
It is not here, Raulkala. Raulkala, my lord. There's the street abandoned cows and bulls, dogs.
If a direction is given to consider representation, will it serve you?
My lord, with your lordship's observation that from April to June, April to October, they have not released any money. That
sentence has to be added. Mr. Monty.
My lord, it is in respect of the commission of
this
Raulkala municipality. They are the independent authority, in fact.
Issue emergent notice. Mr. Monty request me to accept notice for
1.
Copy number 2.
I am for the 2.
Number Raulkala. Always union first respondent, state second respondent.
Right.
Then others.
That is more convenient. Yes, ma'am. Sorry.
Yes.
Item 25.
Lordship
emergent notice. Venerable within 2 weeks. Yes.
Item 25.
May I pray a little shorter date if possible?
2 weeks.
Oh, madam.
May I please, Your Lordship? May I please? Petitioner is challenging the transfer order, Your Lordship.
What?
Petitioner is challenging the transfer order. Petitioner is already transferred to another block. And earlier is come before this Hon'Ble Court, and Hon'Ble Court has granted 8 weeks time and considers the representation. The representation is cancelled by this authority. That way he come before this Hon'Ble Court in second time, Your Lordship.
Lord, here notice be issued because from one block to another block. My lord says in first hand issued this order by representation to be considered. Subsequently, the same was considered and they have passed a reason order. Then now it is at annexure 2 because it is a deployment for a particular time being. So that they have considered for that deployment and returned back to the original.
After that, you will send them back.
Yes, ma'am.
First period up to them. After that, what is the guarantee?
Same day, initially the posted initially posted is one place, then thereafter is deployed to another place. On the same day, same cause of action on 16/9/2025, he is transferred to another place.
How long it is? What is the distance?
60 kilometer distance, Your Lordship. He is a lady, old age in-law member, and the mid session is there also. Thereafter, Your Lordship consider the representation, and only the grounds of 8 weeks time is there. They are considered our representation, but they are cancelled our representation and reverted back to the sent back to the same station.
same post in the same other block, Your Lordship. That must be considered.
But what is which guideline is violated?
One post is vacant also, that the petitioner deployed in that place. In one post is also vacant. Thereafter is transferred to another place. That's also one post is vacant. Till that, my lord, one post is also vacant. Till that there is no join any other person in that place here.
Now you are where?
My lord, notice may be issued.
I'll issue case.
My lord.
But where are you working now, presently?
My lord, I am Majiguda. Majiguda under Zariga block. Majiguda under
Take notice. Take notice. Emergent notice. So he monthly accepts notice from all OPs. First matter lies in a narrow compass. Call off week after next.
Till that no questions.
Till then, not to be disturbed.
If not disturbed, because in the meantime,
I have nothing join, my lord.
because otherwise it will be a communication.
I have not joined any other place.
Well, if you are not already discharged,
Exactly. Relief order is there, but I am not joining any other place.
well, are you released?
No. They passed this relief order, but I am not joining any other place. I am in that place, Your Lordship.
You continue there.
My lord, say
Next data.
if not relieved,
But
because
they will generate some agreement. People are not that.
no, I'm conscious, my lord. Because if other party could have been joined, then it will be a problem for
Petitioner to continue in the same place wherein he was doing his job before the issuance of improved order, till the next date of hearing. First.
if at all other person has not been joined, because otherwise that's okay. If it will not join, no issues at all.
Join the posting question. Item 27. 26.
But here I am challenging order of the disciplinary authority as well as appellate authority. The disciplinary authority has passed the order reducing me to the stage where I was never joined. That I initially joined on the level 13A. I am a registrar of Niger.
Below that you cannot.
Below that, they have
Take note.
Union, I have for all people's practice.
You appear.
My lord, we have instruction to appear on behalf of Niger.
Yes, how many Niger can appear? You are appearing for all?
Yes.
But there is another gentle lady.
I don't know. She is appearing. It is at the instance of DSC.
Anyway, appears for some.
I'll share the extra copy to him.
Yes.
Yes.
Yes, ma'am.
Notice matter to RSCP, my lord. Similar matter has been disposed of.
You are changing the factors.
Yes. Two matters same. Your Lordship.
Wait, please, Your Lordship. Your Lordship, we have challenged the punishment that has been imposed of us arising out of a disciplinary proceeding, as no second show cause was issued to us, Your Lordship.
What was the punishment? What was the indiscipline?
Your Lordship,
Misconduct?
the misconduct was that of my interactions with a female colleague has been termed to be that of inappropriate, Your Lordship. So the disciplinary proceedings, the result of the disciplinary proceedings is that I have been exonerated of the charges of sexual misconduct, but the charge of only misconduct, Your Lordship, that is established against me.
What is that misconduct? Misconduct is a very elastic word.
Misconduct is that I talked with her, I asked her to come to my residence.
Come to?
Your Lordship. Come to my residence. The petition.
Come to your residence?
Yes, Your Lordship. She was.
What time she was called to your residence?
So there is no timing, Your Lordship. The fact of the case is that I had a student's thesis to be defended. So for that, there is a small party that is organized, and I was supposed to invite all my colleagues for that party, Your Lordship. So in that conversation, I have said that while your previous friends were while working in the universities, they used to come to my place and used to hang out. So you can, since you do not have any family over here, you can also come to my residence and we can have, and that is it, Your Lordship. No further.
What further is necessary? Certainly, when a person calls to the residence, it is not for doing puja.
Your Lordship, but the remark that has been given is that I neither had the intention or not the motive to commit any misconduct, Your Lordship. The remark has been given.
Where is that remark?
Your Lordship, that remark is page number 41, Your Lordship.
In fact, we have been observing many students feel unsafe at the hands of teachers.
Your Lordship, this is not
one case.
Yes.
For you, it may be one case. For us, there are many cases. We have accumulation of such cases. And if a student feels insecure at the hands of the teachers, then how Vidyadana can happen? And what about the parents of the children? If I'm worried that my daughter has gone to school, college, and what will happen to her at the hands of the teachers, I do not know. Can I do the judgeship here? So it's a very serious matter where the fiduciary relationship between a teacher and taught is being exploited.
Yes, but Your Lordship, in the present case, it is not between a teacher and a student. It is between an associate professor and a professor, Your Lordship. So,
your client is professor.
Yes, Your Lordship.
Who writes the CR of...
I was not supposed to write the CR of the associate professor.
You take notice.
Yes, sir. Your Lordship.
There, my lord, 2 and 3, they are the panel of lawyers for the university, my lord.
Yes. Mr. PGA Modi accept notice for 1, emergent notice to 2 and 3. Who are panel of lawyers?
VSS in Hon'Ble.
Emergent notice to 2 and 3. Yes.
Your Lordship, one more prayer, Your Lordship, in page number 52, Your Lordship, since I have been suspended till further orders.
Let us see. Let notice go and come back. Returnable within 2 weeks.
Your Lordship, any date before the vacation?
Date I can, 2 weeks.
Your Lordship, but on 15th, the board of meeting is supposed to be held. So in that, if they completely dismiss me...
If any development takes place in the board of meeting, come on, it is open to the petitioner to move that forward. Okay.
Item 29.
Pardon, my lord.
Very exhaustive development happens.
Pardon, subject to your lordship's permit 24. I have another small prayer. Item 24 that...
24?
Yes, your lordship.
Please to Goshala.
Yes, that's an interim prayer. Currently that dues for the current period we paid because
no, we cannot give that. That would be virtually allowing the petition. Let us see. Yeah.
Please to others.
Item 29.
Dependency will not come in the way of the interim prayer being considered by the officials in accordance with law. Interim prayer for payment of the current
disbursement of the
current dues shall not come in the way.
Current.
In this matter, my grievance is against Annexure 1, where the private opposite party has been appointed as a principal in charge.
Principal?
Yes. The government, there is no rule. Government has issued instruction in Annexure 2 and 3
that the senior most man shall be appointed as principal in charge. The reason is the principal in charge is to maintain PIR of the subordinates. So nothing that.
Take notice. Take emergent notice.
Yes, I'll take notice. But one thing, they are proposing to take coercive action against me for making representation against the promotion of the private opposite party.
Huh?
The private opposite party who has been appointed as principal in charge is issuing notice and they are proposing to take action against me. My limited prayer, no coercive action may be taken against me.
How in charge person? What the BN? Take out that Basuraj and Dhotra versus Land Army Corporation. How in charge person will take action?
Yes, they are maintaining everything they are doing. So that.
Take out Justice Nazir Saf's judgment. Are you aware of that judgment?
No,
That Karnataka judgment.
Huh?
Karnataka judgment.
Karnataka judgment.
He cannot discharge any substantial
Any
duty.
substantive function he cannot take.
That you
assigned with the additional charge of principal along with the drawing disbursement.
In charge, independent charge. They are treated almost on par with. They cannot take substantive action. Take notice. Issue emergent notice. AG is requested person. Issue emergent notice. Learned AG is requested to accept notice for 1 to 4. Emergent notice to 5. Next paragraph. An application in IA number so and so supported by an affidavit is pressed into service containing that OP number 5 who is holding the post in question on in charge basis is
Additional charge.
additional charge basis is trying to take some coercive action against the petitioner and therefore it should be halted. First off. The Karnataka High Court in Basavaraj N. Dhotrad versus Chairman signs the Board of Directors. So it's ILR. Not 19, should be 1990. 2004. 94, I do not know. Just tell them. 2006, ILR Karnataka 3163 has held that a person of the kind who does not hold the post on substantive basis cannot take any action. Next paragraph. In the above circumstance, the OP number 5 is restrained from taking any coercive action against the petitioner. First off, it is open to him to seek variation of this order if grounds do exist therefore, since it has been issued ex parte him. Item 30.
May I please?
Yes.
Alert. Here the petitioner's result has been cancelled on the allegation of adopting unfair means. Well, your lordship has already rendered a judgment that I have annexed under Annexure 3 at page 128.
In respect of the same school?
In respect of the same school. And
we said give opportunity and that
yes,
take, this one. That
as per clause 36 of the bylaw.
Who appears for the?
My lord, Mr. Patnaik is appearing.
You take notice.
May I suggest one thing?
Yes.
My lord, your lordship may grant me liberty to move the opposite party number 2 and let the opposite party number 2 take a decision in the light of this judgment.
That issue.
Yes.
Learned counsel appearing for the petitioner having argued the matter for some time. Now, on the suggestion of this court, agrees that his clients would make an appropriate representation to
OP number 2.
OP number 2 in the light of This court's judgment dated 15/9/2025.
Yes.
In WPC numbers 19941 of 2025, etc.
And by
between Om Sai Avatar,
yes,
and others versus
Central Board of Secondary Education and others.
Other. First one, counsel also submits that the subject matter of this petition is substantially similar to the one treated by this court in the said decision. And therefore, he would do what the court has now suggested with joy at heart. What? Next part. In those circumstances and with the above observations, petition is disposed. If a representation is given, OP number?
OP number 2.
OP number 2 shall take a call thereon in the light of the observations in the subject decision within an limit of 4 weeks. First, all contentions kept. The registry to send a copy of this order to OP numbers.
OP numbers
all by speed post.
Item 31.
Wait, please.
This is a case with regard to the issuance of the fire safety certificate, Lordship.
Be louder.
Lordship, this is a case with regard to the issuance of the fire safety license.
Fire safety?
Yes, Lordship. Already, Lordship, similar cases are pending.
Similar matters have already
pending.
Yes,
This is not similar. My lords, kindly see the prayer. Prayer is to consider the application of the petitioner under Annexure 7.
They will consider it now.
If Lordship. As a Lordship, please. Lordship, what I pray, Lordship.
Dates as under. First off, learned counsel for the petitioner submits that if a petitioner's subject application is considered for the grant of fire safety certificate in a normative way and in a time-bound manner, his client would be satisfied. First off, learned AGA Mr. Behura is agreeable with the proposal, subject to the caveat that all contentions of the case should be kept. First off, this is fair. Next paragraph. In the above circumstances, petition is disposed of. The decision on the subject application at Annexure 7 shall be taken in accordance with law within an outer limit of 4 weeks. 4 weeks. After giving an opportunity of hearing to all the stakeholders.
My lords,
first off.
Little more, 8 weeks.
All right, 8 weeks. It is open to solicit from the petitioner or any other office any relevant information or document as are required for due consideration of the subject representation. First off, however, in that guise, delay shall not be broken. Okay. If delay is broken, the same shall be viewed very seriously at the next level of legal process.
Lordship, what I pray, no courtship direction may be no courtship order.
My lord, his license is not in force. What?
Lordship, because in the meanwhile, so-called notice has been issued against us for submission of documents.
Notice?
Yes, Lordship.
That was issued before you applied for a renewal grant or after?
Lordship, earlier I had applied, it was rejected. I applied for the fire safety license, that was rejected. Then after so-called notice has been issued, then I applied for the first new application as per the present amendment, Lordship.
Yes, but it will be waxing.
My lords, this is relating to a clinical establishment.
Correct.
He has no license till 2018, my lords. How will run without a license, my lord?
Lordship, Lordship, I was not able to renew the clinical.
Sir, you applied for your application is dated what?
My application is dated, Lordship.
Not 2018.
No, sir. 2025, Lordship, application is dated. Yes. 1/11/2025.
But earlier date for all these years you have run without that only.
Lordship, so-called notice was issued prior to that. This application.
You file a reply to Shokat notice.
Lordship, I have filed. I have asked.
He has sought for time to comply the requirements.
Because, Lordship, I was not able to renew my clinical certificate.
Yes.
Lordship, till they consider my application.
How that is relevant? Assuming that they are granting your application. Still, that will not be a ground for withdrawing the notice.
Because once they accept, I can.
Serious thing. We cannot do that way. It becomes a precedent for rest of the people. Yes. Item 32.
32, your lordship is identical issue notice and.
You shared a copy with the other
Yes,
side.
it's very same annexure, everything same. I have corrected the number only.
Next. Item 33.
My lord, the petitioner, while serving as a assistant teacher, my lord, her service due to the complaint lodged before by somebody before the police station, the BO Bangamunda, my lord.
You were removed, why?
Removed as annexure 45, your lordship may see page 14.
14?
14, 1-4. Without any notice, nothing, my lord, only by issued by dismissed from service, my lord.
On what ground?
On the ground of fake city training certificate producing, my lord.
Fake?
Fake city training certificate produced by me. 20 years back, I was thereafter, my lord, they have sought from the board, my lord, that regarding the status.
My lord,
Issued that on the same roll number, 2 persons as well, so it may be fake. Thereafter, my lord, the authority again wrote a letter that to the BO, and I have applied. Board has regretted that we made wrong. Earlier, we have made the wrong. That is genuine. And thereafter, my lord, the authorities 3 times the board has already, your lordship, annexure 9, page 19, your lordship may see, page 19, 19. There are now, my lord, I am roaming since last about 2 years. They are not
certificate.
my lord, sir. First they have said that it is.
That's all right. First, all right, over.
Let it.
The genuine certificate is genuine. You take it back.
My lords may direct.
Consider and again come here.
No, my lords, because he has not made secondary board as a party. Now
secondary board also. Why secondary board should be a party?
My lord,
they have
given 2 once they have, my lord.
That happened, and thereafter they have clarified the certificate is genuine.
And they have also regretted that we have.
And we have regretted also. You take notice. I'll call this matter next week. I will not direct consideration. Consideration will never happen.
2 weeks after this.
All right. Call this matter. Issue emergent notice. Mr. Behura is requested to accept notice for OPs. Call this on 17th. Since it lies in a very narrow compass. More particularly when the certificate in question is found to be genuine. Okay. You in the mean you tell your officers. Otherwise, I will impose first time. Then I direct reinstate. Yes.
May I please, your lordship? I am
the penalty of the petition shall not come in the way of reinstating the petitioner on the basis of the genuine certificate. Okay.
May I please?
Yes, sir.
Well, here I am agreed by annexure 1, whereby in the mid of the KMS, I mean Kharif marketing session, the responsibilities which were entrusted to the present petitioner society has been decided to again take back to another subordinate society. Prior to that, your lordship can have a glance to page 55. Page 55, the decision was taken disengaging the Bhatti GPLF from paddy procurement system, and this responsibility was entrusted to the petitioners cooperative society, because the petitioner cooperative society is the primary society. GPLF were involved only during the year 2021, being the SSG. What happened? What thereafter their case were considered, and subsequently by the annexure 1. They have decided to again give the responsibility to that society. Here, according to their instruction, we have proceeded in paddy procurement system. We have initiated the farmer registration. Everything we are in process. And in the midst of the session,
My limited prayer is that we should continue till the session is over. KMS session is over, 25-26. Thereafter, the government may take a decision according to their procedure and other whatever they are.
What decision they have taken now?
Now, my lord, Annex 1, my lord, they have now they have taken a decision to give the responsibility of paddy procurement to Bhakti GPLF Simulia. Bhakti GPLF Simulia, no doubt, is subordinate within our cooperative area. But the paddy procurement responsibility was entrusted to us under Annex 4, page 55. And we are on the way. We are proceeding in that matter. Just 3 months thereafter, this.
What, Mr. Behra?
My lords. My lords, it is relating to procurement of paddy of farmers, my lord. Let me take instruction what has happened.
Next week I'll call this matter.
Because
Behra is requested to accept notice for peace. To others, who all you appear for?
Annex, OP number 8 and 9.
Emergent notice to 8 and 9. No, marketing inspector.
Marketing inspector, my knowledge, can accept.
Emergent notice to 8 and 9, returnable within 10 days. Okay.
And of height and high.
Let us see. Yes.
Because we are in paddy procuring. By much of the letter, we will not be able to procure the paddy. We are in mid of the session. We are continuing according to the decision of the government under Annex 5. It is the decision of the government.
It may create problems to the farmers. How their prejudice.
It will be betterment for the farmers. If the paddy procurement, it will be done from the farmers.
We'll call this matter next week. In the meanwhile, you take notice to 8 and 9. In addition to taking usual steps, it is open to the petitioner to take a hand summons to 8 and 9 and serve them. Call this matter on Monday.
Monday. I have been instructed to appear opinion over 8.
You appear for 8?
Okay,
so appears for 9.
I'll serve a copy too.
Then hand summons to 9. Up. Until 35?
The petitioner had 2 daughters, lords. In the year 1998, he was issued with a green card. And there are some benefits are granted. Green card, lords, who have got 2 daughters. Daughter of the petitioner, after completion of years, appeared in the PG entrance examination for medical PG, qualified, and was called for counseling. And during the counseling, she produced the green card to avail the benefit of green card, milords. The author, because there is a spelling mistake in the green card, she is Sikhyasri, or spelling SIKHYASSRE, but they have said SIKHKYA. So the authority said that because there is a spelling mistake, will not accept the green card, get it corrected, milords. Accordingly, by the Annex 2, milords, the daughter of the petitioner made a representation to the counseling authorities.
Mr. Behra, correct it and bring it next date. I will not direct consideration. Correct it and bring it.
My lords.
Who is that officer? Who is keeping this pending?
Milords, he is Annex 3, page 11, CDMO, Public Health Officer, Ganjam, milords.
How long this has been pending?
Application 1211.
It was granted in 1998.
That's right.
Yes,
he is saying there is some spelling.
No, only
not do it. That also written. Why people are driven to a writ court? Writ court is not a chowdhury.
Where is application for correction?
Given.
Annex 3, page 11, along with all documents.
Mr. Behra is requested to accept notice. Wait, this is one case where I will impose cost.
My lord, in fact, there is no mistake. It is.
He wants certain repairs. Why your officers are not? Why your officers think that all citizens are their slaves? Officers are servants of the people.
It was given on 18th, 12th November.
12th November, all right. How many days required for doing this? Within one minute, in a crucible of seconds, it should be done. He should be asked to take seat. We don't say they should offer tea, coffee, etc. But you should take the document, rectify, give it. Your officers think they are still colonial people.
My lords, in fact, the opposite party number 3 has become hyper-technical. We should have accepted this.
Correct. At least now they want to do something. All officers are like that. They think citizens are their slaves. We are not. We are their masters.
The lords may call next week.
Tomorrow.
I instruct 1 week time maybe.
Call on Monday. So that the representation of the petitioner is favorably concerned and necessary rectification is in the meanwhile accomplished and rectified copy free of cost is issued to the petitioner, filling which personal appearance of who should appear personally?
CDMO, Ganjam Barampur.
CDMO of so and so.
No, sir. Sorry, Lord. OP number 2, Chief District Medical Officer.
CDMO, OP number 2 may be personally brought before the court. Yes.
So in the meantime, the counseling is going on. I made an undertaking before the authorities at the photo that I will produce it. So let them accept my this document.
In the meanwhile, the who should accept it?
OP number 3, the counseling.
OP number, it is open to the OP number 3 to accept the certificate as the green card as the right card relating to the petition. Okay. Notwithstanding certain spelling mistakes. All. Item 36.
36, my lord, is a matter related to appointment of a rehabilitation assistance scheme. Rehabilitation assistance scheme appointment, my lord. Lord, so kindly see page 48, Annex 8. After the order of the Honorable Supreme Court, the School and Mass Education Department issue a list for appointment, my lord. That is on 23 May 2025, wherein my name is finds place, page 50.
Mr. Where I take accept notice?
My lord, yes, I will take notice, my lord.
That's fine.
I prefer interim order, my lord.
What interim order?
But pursuant to this letter, I appointed, my lord. Appointed by the annexer 9 series, 19/9/2025. You must kindly see. Pursuant to this order, I joined in the school at page 52 as a peon. When I continue as such, all of a sudden, annexer 10 series is issued. My appointment is kept in abeyance. Page 54, annexer 10 series. The subject appointment of under arrest scheme.
All right. Issue emergent notice. Mr. Behra is requested to accept notice for all the OPs. First off, an application in IA number so and so supported by affidavit is moved. Seeking will brief at the hands of this first of counsel for the petition argues that the appointment of the petitioner, especially after the reported for those who could not have been kept in abeyance at all, and therefore the abeyance should be kept in abeyance. First off, there is force in this submission. Next paragraph. Ordinarily, where appointment rectifies by the reporting of duty by the appointee, the same is not kept in suspended animation. First off, such cases are very rare in service jurisprudence. First off, next paragraph, in the circumstances of application having been favored, the order keeping the petitioner's appointment in abeyance is kept in abeyance.
Under annexer 10 series.
Therefore, the appointment rectifies. In terms of All right, only this much.
Annexure 10 series. No urgent copy, my lord.
Item 37, can I come back within a few minutes? No. I come back. Okay. Within few minutes. The no square.
Rule 57.
My lord, I had filed a cabinet petition. My friend filed a copy of the written petition on me on Saturday. I have come up with a counter affidavit plus objection to the I. If my lord will permit, I will file it here.
No, it should be filed in the registry.
My counter and objection is ready.
We'll have it on Monday.
I have been just yes, my lord, just because I have to keep one. Only my lord one submission because I am paying for an interim order.
No, interim order. It is against grant of interim order.
Tomorrow, day after tomorrow, any short date, my lord.
Thursday.
Fine.
Okay.
Let him serve in the course of the day so that I can have a reply also.
Right. Next.
Item 38.
My lord, in the meantime, sorry, man. In the meantime, my lantern for the state also take because I am challenging their order also. They are the authority.
In the shoe emergent notice, Mr. Behra is requested to accept notice for
1, 2, 3, 1,
5.
Minor.
1 to 5.
Minor.
1. And 7 are. 6 is
for whom he is
for 6 months.
6 is represented by KVA Council Shri So Council Shri So on KVA.
Not understood.
7 is
a person, an outside institution principal in charge.
Notice
directed to
notice has to go. That notice is therefore call this matter immediately after service. You take hand summons of
hand service in
issue emergent notice to.
Justice service I will take a very course of it.
7. Full stop. In addition to taking usual steps, petitioner may take hand summons to OP number 7.
My lord.
Post immediately after service.
My lord, kindly, Thursday, I am sorry.
Huh?
My lord have stated it will become on Thursday.
No, not Thursday.
So this interim order, it is involved, my lord. I am under suspension by a wrong order, illegal order.
Nothing.
My lord, after service. My lord, any date, my lord. I will only request my lord, next week, Monday. Any date.
Immediately after service, you move it and you take that matter. Yes. Next.
Item 38.
Item 38, my lord. On the last action, we had filed an application for completion of the party, my lord. Petition of the party. But one of the notice has been rendered sufficient, but it is not appeared, my lord.
Call out party. Call out party. Page number 1 is for impleadment.
Yes, my lord. In the 2000, in the first matter, my lord. In the first matter, IA number 17534 is for addition of party, my lord. And my lord, the other application is for amendment, my lord. And we are taking notice by special messenger and it has been rendered sufficient. But he is not there.
Who is that applicant? A person who want to you.
Sambit Rautrai, my lord.
Sambit Rautrai.
Sambit Rautrai, my lord.
Read it. Loudly call that name.
Sambit Rautrai.
Call thrice.
Sambit Rautrai. Sambit Rautrai.
Yes. Notice of impleading application is served. First, name of the person sought to be impleaded is loudly called out by the court officer on instruction of the court. Thrice. And there is no response. First, next, you have the above application in the light of Rajia Begum versus Nasher Jagi Anwar Begum, KAC 886 is favored. First off, petitioner to amend the cost items. Cost item. Okay. You are the petitioner.
No, madam.
You are the petitioner. You amend the cost title now.
I should. My lord, there is also an amendment application pending for my lords.
Amendment is what?
Amendment, my lord, by mistakenly, inadvertently, we had not.
Come this side to the mic. Go to that side or this side. Otherwise, I gather the impression when lawyers do not argue with loud voice. I presume that the case is nothing.
Extremely sorry, my lord. My lord, in the amendment application, we have sought for amendment. It is a formal amendment, my lord. My lord, the plaint and the judgment copy was inadvertently not annexed. And my lord, we have just to the notice of the court by way of amendment.
By amendment?
My lord, the pleading was there. The annexure was there. My lord.
It is not impediment. It is not amendment at all.
My lord, also there was a fact.
Specific pleading is taken.
My lord, there is a specific pleading taken, my lord. There is a specific pleading taken, my lord.
Right.
That regarding the suit that was pending, my lord.
What is this matter about?
My lord, this matter is about we are challenging the order dated 4/12/2019, my lord, where even though the petitioner had produced all the documents before the my lord, his case was not considered.
Yes, for consideration of what?
Consideration of my lord. I'm just coming to the point, my lord.
Where is your farm note?
I'm extremely sorry, my lord. I was not prepared.
There is no such culture in your state.
It is there. It is there, my
You
lord.
will go by plaint.
Extremely sorry, my lord. I was not prepared to argue this matter. It was not.
You'll call this matter day after tomorrow.
Day after tomorrow.
Come along with your palm note.
My lord.
I'm not seeing lawyers preparing palm note at all. Palm note should come within with this. Everything should be, unless your extraordinary memory and other things,
I don't
which
know.
I am not finding anybody. You should bring palm note here. Otherwise, you will be wasting time of the court.
My lord.
Everybody turning the pages.
I apologize, my lord. I apologize. I bow
All day
my lord.
after tomorrow.
My lord. My lord, the amendment application.
Is allowed now. Now you have to amend that one, na?
I'll
Yes.
file the consolidated reply. My lord, for final hearing day after tomorrow.
Whatever order I will pass out. Final hearing itself.
My lord, my lord.
Yes.
My lord, the interim order to continue.
Interim order to continue till for 3 days.
May I pray, my lord, not on 10th, my lord, on Thursday or Friday, my lord.
Thursday?
My lord. Thursday or
Thursday.
Friday?
My lord.
All right. Friday.
Both the matters, there is an interim order.
This date is chosen by both the sides,
My lord.
assuring that they would come with palm notes.
My lord. My lord, there's a written note also we have prepared. We will.
Written note, we will prepare another 25 pages. So we don't have so much time to read all cock and bull stories. Yes.
Highly obliged.
Item 39.
Lord, with your lordship's permission, hope your lordship will not use that stigma to me, which your we concede. We concede to that your lordship said. It is rightly your lordship said, but it has happened. It is said that in always there is ups and downs in the society. ଓଡ଼ିଆ କହିଲେ ଯୁଗେ ଯୁଗେ ଉତ୍ଥାନ ପତନ ଚାଲିଥାଏ. And this patana which started by a person who was presiding this honorable court, thereafter it is going down and down. And what your lordship has said is correct. But accordingly, I am not prepared. But if your lordship will allow me,
No, I don't.
by going through the
I don't use words to you. I use them only.
no.
Youngsters.
No, it's, Milord, it is also applicable to me.
What happens is, I'll tell you one thing.
The whole point is
You
that
read the biography of Bhulabai Desai.
No.
About Bhulabai Desai, there is one book, Legends in Law, by Sudesh Pai, where he has written about Bhulabai.
Here, my lord, we discuss everything excepting law. At least last 25 years. And I used to tell to my junior who has read LLM. Last week I was asking, do you know one of the good jurist, a good judge, a renowned judge of our country? No. Do you know what is called placitum? No. Do you know how to write a citation? No.
Because they are not taught.
No.
Mistake lies with us, not you people.
Not here, my lord. Not here. I'm going to say, if your lordship will permit. Because by going through the file, even though I have undergone in recent past a bypass surgery, but yet my heart is burning.
by going through the file. And for this thing, I will speak something beyond the pleadings. In 1990, one of the exceptional IS with whom I had a very good term, and he was I think he was second to none in our state. So far my knowledge goes, I don't know of any better IS officer than him. He was the first vice chairman of the Central Administrative Tribunal when it was constituted. His name was Bignoraj Patel. He stood first in Bihar and Patna when there was no university in Odisha, Bihar and Odisha in metropolitan, and he got the second batch of IS. And in 1990, he was the chairman of probably Central, still he was continuing chairman of the Central Administrative Tribunal. His house is just left side of the governor's house. And incidentally, the new government came in 1990 after Biju Patnaik lost his election. And the moment thereafter, he said, we used to talk a lot of things. Not your lordships are saying, your lordship, in fact, it's not a oiling, but I'm surprised to know that within such a short age, how your lordship has encroached in so much of, avenues and so much of subjects. Little bit what I heard, because there is a saying, the reputation is earlier than the man. And what I saw and what I heard. He told me, at that time till I didn't cultivate what is a soft state, he said, we are marching very fast towards a soft state. He started our discussion on that day. And hardly 3-4 days or 5 days it was there. The new government had come, who was reputed to be very ill-reputed in the state. Because he had earlier also in the government. Then what is a soft state? He narrated. Because soft state is directly related, because what your lordship said to him, that you are the government servant, they feel that they are the masters. In fact, they are the servants. But my lord, your lordship also knows much, much better than me that for thousands and thousands of years, from Rama Chandra, Krishna Chandra, like that, we are in a feudal state. We do not know anything what was democracy. Till little bit the colonial democracy taught by the rulers, the then rulers. Then he narrated what is soft state. Which of the countries in the world are going to the soft state? And because soft state is directly related to the law, I was a little bit able to grasp better, and because my bent of mind is hearing to that thing is a little more, inherently more, then I very silently and very concentratedly I heard. Then he said, we are going marching towards a soft state. Then I narrated that how it started. It started right from 1947, the day we got independence. Then there was a discussion. He knew that my father was a member of the Constituent Assembly because he happens to be the same district which I belong, and he was a student of my father for some time. Before he went to law, he was for 5-6 months, he was his teacher. So what was happening in the Constituent Assembly from provisional parliament, my father had told him very, elaborately. Probably before that he did not say to anyone, because I heard from some others that when we discussed a lot, he never said to, I don't know why he didn't say. I will ask him when I will go outside to the other world. How they were functioning and how Nehru was getting annoyed. So that I narrated, which I am not going to narrate now because it will take a long time. So the country, the future of the country was visible from that day. It was dark. Because that prompted my father to say, because he was the last but one youngest member in the Constituent Assembly. And I said, you are so young, you are a member of the Constituent Assembly, whatever you may be your philosophy, his philosophy was left. But in the parliament, he was known to be a Congress member. Then you should have borrowed some 4-5 crores, you would have now enjoying the Mercedes car and etc. instead of going in cycle and scooter. That prompted him to say to narrate this entire incident. And he said that we cannot adjust with the future type of politics. There was politics in 52. Again, he rejoined the bar because he was a lawyer and earned a leave. And man with a terrible presence. He did not say all these things before the public or anything. Even he contested the election in 52, lost, against the then ruler because he was known to be a very cunning person. Thereafter he continued with the practice, just earn and leave. In this he said to me, when he had already asked to sit on the ground of health because he had also heart problem. We have got some little genetic problem. Then this I said, I heard how we are marching towards a soft state. And each day I am thinking and I am seeing how we are going down and down by so-called the rule of law here. And as your lordship said, it is rampant, unthinkable. Yesterday I was sitting with one of my friends, I don't know, he recorded it. How a SDO behaved in 1972 to one of my friends in granting a solvency certificate and how I reacted there. And today morning I was told that we saw this thing, that thing. I didn't know that he will make it viral. First time, of course, it is made viral for me, but I don't appear before TV or others. Then I am marking and observing how we are collapsing the rule of law. Then I read the news, which your lordships might have read also. The half-page interview by Mr. Santibhushan in the year 1994-95. And the gist is that it was half-page printed in Times of India. And it was an open interview. That almost all Supreme Court judges and High Court judges have become corrupt. Unless serious measures are taken in view of the collapse of the political administration, executive administration, the system and the country itself, the administration of the country itself will collapse. And at that time, your lordship knows, he was already a minister in the union. And he had a good practice, a good reputation throughout the country. And he's making allegation against, he's saying that almost all the Supreme Court and High Court judges are corrupt, knowing fully well that he will be prosecuted, likely to be prosecuted. I never saw such a daring person after 47. Before 47, something different. Then he, having all the facilities, all the financial abilities, dignity and everything, he warned and cautioned the country. Then I developed an inquisitiveness. He might have his counter filed in the distribution because there is always chatudars, because many people will like to please the boss, whosoever it may be. We have seen here someone who are ill-reputed and later on they went to jail also. But we have to appear when they are sitting there. One of the judges who was there, from the day one we knew that he is highly a corrupt person. But the laws, as you knows, you are law, so you was also a lawyer. So we are compelled in various circumstances, we have to appear except in the...
Then just what you say is, there is a downgradation.
Terrible.
Terrible. Perhaps adjective, on adjective one may be arguable. It may be arguable.
Yes, according to me, I can speak. Therefore, and why I say I can justify it by saying hours together.
No,
without not here, in another place.
No, I understand. Yeah, I understand your concern also. Therefore, because the youngsters come here, I insist they should come with full preparation.
They should.
And whenever they come, in my court, generally they come with preparation, going by my nature. And they are rewarded also. I reward them.
No. The whole point is that, my lord, there was a judge whose name was Mr. Dixit Krishna Mishra, in whose name your lordships have kept that memorial hall. There was nobody better than him, and nobody has come near to him also. Of course, what we found from your lordships, at least from the day one I saw, at least I have not heard, excepting Mr. Justice, the Supreme Court, who was Chairman Law Commission, I am forgetting the name. But he was giving a lot of judgments. But your lordship while hearing the Land Council, the manner your lordship referred an old judgment, giving the citation, giving the page, paragraph, as when he still was going on arguing, your lordship said, without being annoyed, that I gave the proposition that there is something what we are arguing, there is a law laid down by the Supreme Court contrary to it. So why don't you go through it and sell it? That should be normal, because it says it was adjudication as well as education. It was going on in 80s. But it all went out after one Mr. Pukon came, he blew And he made the High Court. I requested him not to say before I complete and before my court stopped me. Then
Many people
are there.
Many people will be.
I know, I'm coming. I know.
Proceedings are on.
And I said that my heart is burning because of the nature of the case. I will say, come. Thereafter, I discussed out the everything with another renowned IAS officer, namely Mr. Hon'Ble, whose father was a cabinet minister, but he was honest to the point. And later on, he became PSC chairman. And I was discussing, he was a neighbor to me. So he was around 14, 15 years elder to me, but somehow other we came in contact with him, we had some good relation. When I was discussing with him for some time and narrated this thing of the Constituent Assembly, he said what to speak of 47. In 1922, Rajgopalachari has said, which your lordships might have read. And that is I am placing.
Elections and corruptions will make India a hell of a country.
Exactly. But for the bar, if your lordship will permit, I will read. We all ought to know that Swaraj will not advance, or I think even for a long time to come, be better government or better happiness for the people. Elections and their corruptions, injustice, and the power and tyranny of wealth and inefficiency of administration will make a hell of life as soon as freedom is given to us. Man will look regretfully back to the old regime of the comparative justice, efficient, peaceful, more or less honest administration. He has not given full mark. The only thing gain will be that as a race will be safe from dishonor and subordination. Hope only lies in the universal education by which right conduct, fear of God and law will be developed among the citizens from childhood. It is only if we succeed in this that Swaraj will mean happiness, otherwise it will mean a grinding justice and tyranny of wealth. Here are some few people who are going with the rule of law. At least I know 2-3 people, and I know how they are mentally tortured. So in this case, in this background, now I am coming to the case.
Yes.
These are the type of case, my lord. In our earlier days, it was not taking even 5 minutes.
When you mentioned these things,
yes,
since you are very senior to most of us,
yeah,
and very straightforward also.
Not in knowledge, but in age. Not in age, and some experience.
Your perceptions,
some experience.
No, your perceptions you have vented out.
Little bit.
A little bit.
There are many things.
That's good thing. That many of us kept quiet. It does not mean we subscribe to that.
For that, I am obliged. It's not that I don't say that your lordship accept it.
No, just this is only a clarification because people will be seeing the court proceedings, etc. It is not that what all you said, what all others said, we will subscribe to that.
No, never.
We should hear what is being spoken.
No.
That way I have said.
What your lordship said, that the government servants, that people will listen more patiently and think that it's correct.
Correct.
That your government servants, public servants are behaving as if they are the masters. In fact, they are the servants because that is the law.
That's the law.
That's the law. Your lordship is saying the law.
Correct.
If the law is not uttered very less by the authorities.
Correct.
The whole point is that here, now I come to the case. This petition has been filed in 2015.
Yes.
This gentleman happens to be a classmate of our present chief minister in the hostel when they were staying.
Yes.
Incidentally, he became a Shiksha Sahayak of some school, and he went in politics and succeeded like anything.
Shall I make small notes with me?
Here, my lord, your lordship kindly here, I am telling, this type of cases before Justice Hansaria, it was not taking in 5 minutes to dispose of. Because the impugned order is passed without gross violation of rule of natural justice, without notice. And in contrary to
what is the impugned order?
My lord, I did not know anything.
No, what is that impugned order?
Your lordship can see.
Number?
I was, first of all, I was dismissed from the school without a so-called prayer. Please, I am answering to everything. Either you say I am sitting. You sit. I requested you from the beginning. I know you are very excited people because you are very highly charged.
Yes. Where is the impugned order, sir?
My lord, Annexure 7, the order passed rejecting my caste certificate.
Dated
behind my death.
Annexure 7 is dated.
My Lord, this is page 35. Page 35. This is passed behind my back. It is 1/11/2014. 1/11/2014.
2014.
This is my case. Yes.
It's relating to caste certificate.
Caste certificate by that committee as per that Patil case.
Madhuri Patil.
Madhuri Patil case.
Madhuri Patil.
Yes. In the culture, they are.
This is a committee decision.
You keep quiet. You will listen something which will again break down the peace.
No, sir. Sir.
They should stop because only your lordship should ask me them.
So that.
And here.
Well, one thing. Why at all we should lose patience? We are not paid for that.
These people are honestly prompting for that, inviting.
May not.
No.
Anyway, sir, this is a committee decision.
Yes.
Committee decision.
Committee decision behind my back. I came to know first time when I was dismissed from the school without a notice. Thereafter, immediately I was arrested by the police. Thereafter, I came to know.
1 second. 1/11/2014 is the order challenged in the petition.
1/11/2014.
This was challenged in the petition.
My Lord.
Then let us go to prayer column.
My Lord. Prayer is page 15, last 2 lines. This Honorable Court may please to allow this petition pass the impugned final order annexure 7 of the writ petition. Consequent upon passed on the basis of annexure 7, like annexure 5, 6, 9.
Yes.
All to be passed.
Now this order is passed under which section?
And the prayer is Mandamus directing, which I am insisting, Mandamus directing to the party to restore all the rights, service, caste certificate, because he, my Lord, your Lordship, kindly see, this matter on my this petition, it was listed last on 19. I became vexed. Your Lordship knows the law don't get salary like the ex-USSR, where they are paid, both the laws are paid by the state. So it was 19. I made a lot of mention. I tried a lot to get him appointment. But somehow it was going on, it could not be completed.
Today,
no.
Now, this is under which section?
Which one?
This order passed under which section of which law? Impugned order.
Law within that caste certificate, Madhuri.
Which section? Which rule?
Rule, they have formed the rule as per that judgment.
Give them.
Yes. Your Lordship, I say they have not referred to any rule. Annexure 7.
No, according to you.
My Lord.
Under which law this has been, they
don't say anything.
They might not have said. Right?
They have not said anything. There is a completely perverse and vague order. If they have not said anything, why should I put it?
No, court is asking you.
My Lord. I say that this is on the of that Madhuri Patil case. They formed a committee of 4-5 members and they passed an order and who are not accountable to anyone on this earth. They have punished me. I am out of service. My family is ruined and he is not able to come to the Kotak also to give me the up-to-date instruction because he doesn't have the money to buy the ticket. And that is why I have
Is he your client?
No. He is my clerk. Client is not able to come. Your Lordship, as you see, last list is listed on 19. For instruction, let me explain.
I am ready to hear you. On merits itself, I will hear you now.
That's what I am saying. I know. My prayer is that only.
Yes. So 111.
I requested him that unless you pay instruction, how I will track instruction, how I will proceed. And we don't get salary from the state or from anybody.
Yes.
So he was a teacher.
When are the defects in the impugned order?
Defect is hard without a notice.
One is
that is the only thing.
Yes. Okay. Submit.
Your Lordship,
the order has been passed
without a notice as per the law,
contrary to the principles of natural justice.
That is Madhuri Patil case, paragraph 6. Director concerned on receipt of the report from the vigilance officer, if found claim of the social starter to be not genuine or doubtful or spurious or falsely wrongly claimed.
95 Supreme Court you are reading.
My Lord. It's just to send by registered post. I have stated in my writ petition that after coming to know as a shock, I applied for the certified copy of the entire order sheet. That is not given to me, and that is not denied by the state.
Your first contention is you were not heard in the matter.
No.
No. Now, second contention.
I applied for certified copy of the entire order sheet. That is also not given and not disputed in the counter also.
The entire certified copy of the papers,
order sheet,
not order sheet, has not been given despite request. And thus, the petitioner is put to some disadvantage of prosecuting the petition.
To assist your lordship in a more proper manner, that notice is not given.
Number 2.
And they went on dismissing, arresting, and everything. And when he started when he started crying repeatedly, even without fees, which my land friend said that, when I said that he's a classmate of Chief Minister, how he would have engaged you, thinking that as if he is a very rich client and engaged the law by giving a lot of fees. But this is completely out of pity, which I rarely do, because I do, that is only in exceptional cases. This is a case where he could not come. Even though years together I was telling that you come and give instruction, and from 19, I tried a little bit, I failed to get him purpose in the as per the judgment. Even in this situation, he should be appointed. His services should not have been terminated. That is why I filed the IA for immediate reinstatement. So what I pray now, my lord, this entire order sheet may be quashed. The person concerned should be called into question, and the entire benefit should be given within, if not earlier, within a week, by restoring my service to my place. Yes, if your lordship will say, call the state authority to bring him, your lordship can see his condition.
Yeah, that's fine.
For 5 years I have been trying. Just you come, I will fight. You come.
All right. If order is in violation of principles of natural justice, the Supreme Court has said, you send the matter back, give an opportunity, and pass the final law.
Exactly.
1 second. I'll come back to you. Mr. Behura,
in another
whether an opportunity of hearing was given.
My lord say he didn't avail the opportunity. Notice was served to him.
How notice was?
My lord.
Now I am asking you.
My lord.
If you give one more opportunity, I will fix a date. Within that, you give notice to him, let him file objections, and what period you will be doing these things? You cannot keep it for a year.
No, law is something different. Law is something different. They will inquire as per the law. Law is there. The whole point is that my certificate is how that is false. That has been enumerated in the special law. Your lordship can see.
I will tell them to follow that law.
That law has to be followed.
Yes.
That after that inquiry, by following that law, then if the report is submitted, then notice is to be given.
Everything will be done now.
Yes.
So that they will do within a period of 3 months. It was necessary because because of Madhuri Patil also.
I understand.
There is a big procedure.
Yes.
Let them follow that procedure.
No, that is
you also participate.
That has been enacted as a law.
In your state, there is an enactment.
Yes.
Therefore, Madhuri Patil may not be applicable also to you.
What is there in the Madhuri Patil? That has been brought as a law. Everything.
Yes. Let them, you follow this judgment. You give opportunity
that is the law, my lord.
To the petitioner.
That is the law. That is a statute. Now that is a statute. What your lordship is holding.
Matter of 2014.
Yes.
Now the law came in the year 2023.
Correct.
My lord, can that be applicable here?
What a strange submission is made, my lord. The law is there from Madhuri Patil case. There, what is there in that thing? That is the law.
We can't say it is a relevant argument. What Mr. G has said is very relevant because you are speaking of statute law. He is saying the incident took place before this enactment.
I said, sir, before that, I said that this is a continuation of the law, and
we do not know. We do not know. No, then what we will do is we will direct them to do the things in accordance with Madhuri Patil. Madhuri Patil.
Yes.
Because
same thing.
This is in one matter I have held.
I think that is retrospective also. This law is, I think, retrospective also.
No,
I have held it as prospective in when the matter affirmed by the division.
It makes a difference. What is laid down in the law?
In the order, the Madhuri Patil was referred to.
And but that is not the way I went through the order. The way with the due seriousness with which you should.
My lords,
and the notice to him.
My lord,
Now,
by registered post.
maybe that he has not taken, availed that opportunity. Social status is a very important
My
thing
lord.
in our setup.
My lord, I have respect.
I concede to my lord's proposal, but here is a case. It is a fake certificate because his father is a OBC. He has obtained a certificate of scheduled tribe. And secondly, there was a notice by affixture in his house. He refused to receive the notice and now claiming equity in a writ court, my lord.
You'll also kindly see the
I agree to
what the law says. What the law says?
No, it's all right. Now,
Law says it is by registered post. My lord, what is my averment in the pleading and what is their denial? And these people are saying something which is beyond the pleadings.
No.
even
It is
the petitioner,
With
he-
another aspect, my lord,
against
my prayer, that he should be immediately restored if he wants to survive, otherwise he will die.
that cannot be.
Service.
Because this has to.
No, this is, my lord, your lordship, can you see the other judgment?
Yes.
Another judgment is there. Subsequently, that is, in the IA I have referred. Here, even this case also that can be given.
No, that I will not give.
Your lordship, can you see?
Yeah.
That is report. That is the case civil appeal number 8928 of 2016. So in this case,
Name of the case is?
my lord,
Name of the case?
this is a
Laveti Giri versus so.
my lord, chairman and managing director FCI and others versus Jagdish Balram Bahira and others. Your lordship, can you see? On this basis, that is why I filed a petition for interim appointment.
No appointment.
Then he will die, my lord. Then he will die. In the process, everything he will die.
Within 3 months, nothing will happen.
Your lordship,
3 months, if he dies, who can prevent that?
No.
We cannot do
The
anything.
law can prevent. Law is preventing.
Law cannot prevent death of anybody.
No, once the impugned order goes, then he should be restored back to his service. No. That is the simple thing. How can I be removed?
I will treat your submission.
That is different thing. That is my prayer only. The whole point is that the moment my lord,
Petition is allowed in part number 1.
My lord, one thing.
On the following grounds.
May I submit one thing?
The first contention that the petitioner was not given an opportunity of hearing and therefore he had no participation in the proceedings in question appears to have been substantiated, notwithstanding notice, a fixture of notice to his house.
Law in Madhuri Patel case is not followed.
The second contention that the observations of the apex court in Madhuri Patel versus State of Maharashtra, AR 1995 SC 94, has not been followed. 3. Justice should not only be done, but seem to have been done, is perfectly applicable in this case. Yes. First off, the last vehement contention of the senior advocate appearing for the petitioner that once the impugned order is set at naught, no vacuum should be permitted to be created, and that the petitioner should be restored to all his original positions which he had on the basis of the subject caste certificate is too wide a proposition and therefore cannot be accepted. More particularly when a fresh inquiry is being ordered in a time-bound way and with full opportunity of participation to the petitioners, as rightly submitted by Learned Counsel Mr. Behra appearing for the state. First, next paragraph. Where the impugned order is set at naught, it is not that the reinstatement of in service would automatically happen. Courts in general and the constitutional courts in particular will have to mould their relief, keeping in view several host of factors and the implications as well. First, in the above circumstances, the petition is allowed. The writ of certiorari issues, quashing the impugned order. Matter is remitted for consideration afresh at the hands of
My Lord's committee.
Which is that? OP number?
One.
OP number 1, which shall follow the law as declared by the apex court in Madhuri Patil, without venturing into the 2023 rules, these rules fully orderly, which apparently are prospective in operation. However, wisdom from the rules may be drawn wherever need be. First, all contentions of the parties are kept open. Next paragraph. Petitioner to appear before the committee. On which date he will appear? On which date he will appear before the committee?
For what?
For to appear before the committee and seek instruction and
let them follow the rule first. Let them inquire. What is to be done? You logically see the judgment. What is their entire thing in the judgment? That is there in the rule that made. There is nothing new in the rule. And what is the inquiry they should do before giving me notice? You logically let me play the judgment. Let me play. That is what I said. They cannot do. The judgment requires something, a large number of things. You logically see.
I remember every paragraph of the judgment. I can reproduce.
I believe.
I can reproduce. I believe. Time of the court.
I believe.
Yes.
Once your lordship said that, I remember. I believe.
Yes. Therefore, whenever they issue notice, let him respond. You send notice by speed post now. No register.
What they will say, they will so call and asking me a so call without doing all necessary inquiry and everything, and they will reply. They will pass an order.
Follow the law declared by the apex court in Madhuri Patil versus so and so. First, entire exercise has to be accomplished within an outer limit of 3 months. Within
Provided he cooperates, my lords.
If he does not cooperate, there is Madhuri Patil looks after that issue also. That also.
Yes. Everything. And failing which your lordship may say that his services may be restored.
Delay shall no. Such cannot.
My lord, if your lordship will see the type of order that is in past, certified copy of the order sheet is not given. He has been not given hard by anybody.
Therefore, to put an end, the object is to do justice to your client. Not getting an order.
Provided he is
to do justice to the litigants.
Litigants, I understand. That is what, my lord, with all respect.
We stated that all papers and reports that are generated in the course of the inquiry shall be punished to the petitioner to have his say.
Yes.
Okay. I have everything. Very there to be written.
Whatever is there, your lordship said
everything.
Everything is there in the Patil case, and the entire case is being enacted as a law.
Correct. Yes.
Nothing more.
Yes.
The law, that registered post notice, that is to be given. And one thing, my lord, your lordship may kindly say that failure to this, there has to be something to comply this.
My lord, unless he cooperates, my lord, he doesn't receive notice. How?
Lord, if you will not cooperate, your lordship will say that he should be hanged.
If there is a failure, that will be a fresh cause of action to you. Again, he will come to you.
I will never accept him now. My lord, the whole point is that. The whole point is that, my lord, I don't have such a good connection in reputation by which a lawyer earns little more than the general lawyers. That is why from 19... wait.
I am about colored paisa.
Nonsense you are saying. Language to be spoken in the court. What are you saying? Is it the language to be said a lot?
Not Mal. Anyway.
Mal. Mari dalo.
Anyway, now it is a... will disperse. Our time is not that good today.
No, it is good. It is good. But it is good. But the communication should be done. Is a manner communication is to be done.
One thing, what all you said, I noted because they are important to the youngsters also.
No, not necessarily.
Youngsters.
Because nobody listens, nobody heard Gandhi. Here, there, everybody has come for money. There, nobody will hear. The whole point is that after 19 here, I only say that your lordship said failure there has to be something. On failure of this compliance of this order, your lordship may pass some order in favor of the petitioner.
It shall be viewed very seriously in the next level of application. All.
Obliged.
Your Lordship may kindly take up WPC number 8516 of 2024. 8516 of 2024.
Yes. Rest of all matters are connected.
All the matters are connected.
All same relief they want.
Yes, yes.
And factuals are same, law is same.
Yes, yes. The termination order is under challenge.
All they are terminated.
All they are terminated.
On the same cause of action.
Yes. Same so cause notice, same so cause notice. Then explanation submitted. No inquiry was held. No consultation of the collector was made as per the scheme.
What was the charge?
Well, the charge is unauthorized absence.
Unauthorized absence.
Yes.
For all of them different spells of period or
same period. Same period.
Same period. From which date to which date?
Yes.
What were they?
Well, so far as my client is concerned, he was appointed as a special educator against a trained intermediate post on 4/3/2019 under the
Appointment was, all they were appointed on different dates.
Yes, different dates. My client was appointed as special educator, that is a trained intermediate post. On 4/3/2019 under Annexure 1.
Yes. All that is not in dispute.
That is not in dispute.
Yeah. Who appears for the other side?
Well, for the opposite party, number 5, I am appearing.
5 is institution.
Yes.
Aided institution.
Aided institution, Your Lordship.
Yes.
And
any objections, counter?
Well, a counter affidavit has been filed, Your Lordship, explaining in detail that Malats on multiple occasions show cause notices had been issued.
No, one second. I wanted to know. During what period they were absent?
My lord.
Is it one spell of absence or multiple spells of absence?
My lord, their allegation is that so far as my lord, they remained absent according to them. That is not correct, of course. That is since April 2020.
April 2020 means there should be some ECIL says date should be specified, na?
Your Lordship, may kindly see the so cause notice. That is under
which date to which?
It is observed, paragraph 2. It is observed that since April 2020, to note the headquarter without prior permission of the district collector, which is the standing order of the government, for which the school was put in an embarrassing situation. It is also observed that without taking permission either from the collector Ganjam or from the DSSO Ganjam or from the management of the association, who have gone to participate in the state level strike before the state legislative assembly, by which the reputation of the organization was hampered before the government, and the government also blamed before the public by your nuisance works. For the greater interest of the students, our management has decided to conduct home visit classes, and each staff has instructed to visit at least the home of one student daily in their locality to impart education at their doorstep. But you have not honored this decision of the management also. In this context, you are there to submit the written explanation to the undersigned within 3 days. Thereafter, my lord, Annexure 4 is the explanation submitted by the petitioner. Thereafter, your lordship, I kindly see Annexure 5 at page 16.
No, let us see your explanation.
Yes.
In April 21.
21.
20 or 21?
That is 25/10/2021. Explanation was submitted.
No, not that. Brother, you appear for the institution.
Yes, Your Lordship.
Who has issued the show cause notice?
My Lord, the secretary of the institution, Your Lordship.
From which date he was absent?
My Lord, that is from...
April has got 30 days.
Malats?
April, in Gregorian calendar, it has got 30 days. In Caesar's calendar, it has 38 days.
My Lord, on 25th of April 2020, they were absent. Then in the counter,
date you are not telling. Absent should be from a particular date to particular date, that way. In April means on a full stay, or which day of April?
They say that you left the headquarters without permission of the district collector. This is the only allegation.
Have you denied it?
Yes, yes. Your Lordship, may kindly see. And this so-called notice was issued on 18/10/2021, Annexure 3, the first so-called notice. And explanation is under Annexure 4.
1 second. The academic year comes to an end on which date?
My Lord, that is May.
So it was during the academic year you left.
But they did not indicate about the.
No, that wants to know.
That since April 2020, you left the headquarters without prior permission of the district collector, which is the standing order of the government, for which the school was put in an embarrassing situation.
Now, therefore, I wanted to know.
Yes.
When the academic year comes to an end in your state, or for this school.
So far as these are special schools.
Special schools.
Special schools. Meant for disabled children. Meant for disabled children. Then your Lordship, may kindly turn to Annexure 4 at page 13. The explanation put by the petitioner.
School for disabled children will not have academic year?
Yes, yes, academic year is there.
Therefore, I am asking.
That is, yes, that begins from April to.
Where is that?
My Lord, that is in the calendar. That is there, but that is admitted.
No, I don't admit it. I dispute it.
Then, my Lord, I will produce this. The calendar, school calendar, and my learned friend will also produce. He is having that school calendar.
Absence of an employee in an educational institution.
Yes.
During academic year is one thing.
Yes.
After the expiry of the academic year is
another thing. Yes.
That is how the service jurisprudence.
But here there is no allegation against unauthorized absence. They say that you left the school without obtaining the prior permission of the collector.
What is your reply?
Well, my reply is under Annexure 4 at page 13. Well, Lord, your Lordship, may kindly.
What do you say?
May I please.
No, I'm asking you. Did you take permission?
Yes, yes. As per your Lordship, may kindly see paragraph 2. As per your letter, I have left the headquarters of the school since April 2020. It is to note here that.
So you left the headquarters is admitted.
Yes, that SEC PD department issued letter bearing number such and such, dated 21/4/2021, that staff wishing to leave headquarters during pandemic situation arising out of COVID shall take prior permission of collector and district magistrate through concerned head of the institution and DSSO. So before this letter was issued, I have been performing my online classes every day, remaining in a rented house near school on Google Meet, which you have passed in aided school SCCPD group every day, and as per on your absent statement report, I have received my remuneration till April 2021. So explanation on the salary period not necessary. Besides that, as per the letter number such and such, dated 21/4/2021, our school arranged roster duty with 50% staff at school point. Accordingly, I have performed my roster duty at school point as per your notice. When I have performed my duty at school point, then how could I left headquarters? So when I have remained in headquarters for performing my duty, so prior permission, district collector, DSSO not necessary.
Therefore, your contention is two things are admitted.
Yes.
You remained absent is admitted.
But he was taking classes.
I have not taken permission is also admitted.
Like he was taking classes, online classes he was taking.
Well, we will come to that one.
Yes, yes, yes.
The things, let us have the facts first.
Yes.
Absence is admitted.
Yes. He has said that I never remained unauthorized absent.
No permission is taken is also accepted.
Yes, because that was not necessary. That was not necessary.
Is not a legal requirement.
Yes. That is during the COVID period.
Your reply is there is no requirement of such permission.
Yes, there is no requirement of such permission.
Who says permission is required?
My Lord, may
management says.
Allow me
show that.
Place the counter affidavit. It begins with page 9.
All that page I am not. This is a writ court. It's a writ court.
Yes.
This is not the first appeal.
Yes.
To read every page. I will not read. Answer the question.
Yes.
Which law requires permission?
My lord, the collector, my lord, we have issued one office order.
Show that.
Which is at page 9. It is with regards to the instructions given by the collector, your lordship.
We do not the whichever.
Page 9, your lordship. Annexure C by 1 series in the counter affidavit, your lordship.
Page 9.
Yes, your lordship. Yes, your lordship. And as per in response to the orders of the collector, my lord, due to the spread of the pandemic, my lords, coronavirus, and to prevent, has decided, however, Collector Ganjam has instructed to remain and present and remain alert all the staffs in the institution and should also be ready to cooperate with the district administration at the time of necessity. District Social Security Officer has also requested all the staffs to remain alert at the headquarters.
Under which authority he says that?
My lord, as per the directions of the collector, my lords.
The collector gets the authority which law?
My lord, as per, my lord, there are the 2022 guidelines, my lords.
Show that.
Yes. The recognition, my lord, this is the 2022 guidelines, your lordships. And in that, my lord, yes.
Yes, Disaster Management Act. There is one central legislation, Disaster Management Act. Which is detailed. Any notification was issued
Yes.
under Disaster Management Act?
Not Disaster Management Act. But here, for special schools, there is a notification. That notification I have annexed. Your Lordship may kindly see under Annexure 9 at page 20. My lord, these schools are under the Department of Social Security and Empowerment of Persons with Disabilities.
No, not the question is not that.
Yes.
During disaster, this is a special act.
Yes. During disaster.
When notification is issued under Disaster Management Act,
yes,
Deputy Commissioner gets, the District Collector gets power to ask anybody to be at the headquarters.
Yes.
I'm just asking whether there was such a notification.
My lord,
to that effect, my lord, there was no specific notification. But
whether state also is a party.
No, it is a party.
Under this act, there was any notification was not this Disaster Management Act. One more act.
There is a notification on 23rd March 21 issued by the Government of Orissa, Government of India under this Disaster Management Act.
23
March 3/21. Guideline also issued there on the COVID guideline.
That you have to look into.
Yes.
If that requires that you cannot leave the headquarters, you cannot leave it.
Yes.
Simple.
Yes.
If you leave it, various high courts have taken the view, dismissal is justified.
Yes. But besides that,
any research, or you want to argue right now?
No. Well, I will take time to answer. Well, may I pray one thing? Well, now during the pendency of the writ petition, my lord, large number of teachers have been disengaged on the same ground that they have not taken prior permission. Now they have floated an advertisement to fill up those posts. Your Lordship, may kindly say I have filed one IA. My lord, may kindly take up my IA.
Why IA? I am argue the main matter.
Yes. My lord, they floated the advertisement on 7/11/2025 and it is 10 to fill up various posts, including the post of special educator, that is trained intermediate teacher. And process has already been started.
Why not 30?
My lord,
What's the matter, main matter? Those who left.
they have not left.
You have admitted I have left. You have said I have not taken permission. Your contention is there is no such legal requirement.
My lord, he was
So facts
taking,
are established.
my lord, he was taking online classes.
No, that is the question is not that.
Whether they have taken or not.
You may go to Alaska and take an online class. That is not the question. Your presence was required under the Disaster Management Act because whole society needed your services.
Yes,
State was to be on the alert.
Yes.
You are part of your civil servants.
Yes.
Therefore, that misconduct.
Yes.
If suppose you run away, suppose during some attacks by the foreign enemies, if our soldiers run away, what would happen? Similarly,
yes,
it is a disaster period.
Yes.
During that period, special powers are given to the state.
Yes.
So you were asked to be at the station. For what, we do not know. The state will be able to know all those things.
Yes.
And if you say there was no such requirement, then the question arises whether there was notification. Then
yes.
Notification was
that point I will examine.
2021.
Your Lordship is absolutely correct. I will examine that point. Besides that, my other points are.
Necessarily wait. Yes. Other point hearing today, some other points now tomorrow, yet other points a day after. I never
some
do that.
legal points.
Ready? I am hearing the matter. Legal point means during the disaster, law will take its own twist and turn.
Yes.
Just look into this.
Yes.
There are various judgments.
Yes.
During a disaster period, if those who run away should not be entertained. Just look into that and come back. Day after? Next week.
Next week.
Next week.
All this matter
next week at the request of learned advocates appearing for the petitioners who want to come with more preparation.
Yes. May I pray one thing? That selection process may continue, but no appointment may be.
No.
Otherwise, it will.
I may not. I'm not much impressed. Even little, I'm not impressed. Let us see.
But here there is no.
We will do that. Yes. Okay.
Item 41.
Your Honor, humble submission, I am representing for opposite party number 2 and 3. I pray for time, sir.
41.
Yes, sir.
My lord, I have filed one substitution petition, my lord. In the meantime, the sole petitioner has died and his legal representative are on record, my lord.
That LR application will allow.
So, my humble sir, submit this IA application before the office of the university. So, for that, in respect to that, I didn't get any reply. So, okay.
Need to reply. But when he died?
Yes, sir.
Which petitioner?
My lord, Subhash Chandra Behra. He died
on
18/9/24.
Petitioner died on 18/9/2024. First of all. One application or 3 applications? Nothing. No delay?
Delay is there, my lord. My lord, but this is a read proceedings.
Correct. No requirement of separate application. Have you explained the delay?
Delay has not been explained, but section 141 of CPC in explanation it enshrines that it won't applicable to read proceedings.
No.
This in stricto sense.
No, not like that. You have rules here.
Yes,
you made CPC applicable to read proceedings.
High Court rules.
That is subject to an exception.
That is chapter 7.
Petitioner having died on 23/3/2021.
24. 18/9/24.
18/9/24.
Yes, my lord.
18/9/2024. His LRs have. Yes, how many LRs?
Three. Wife and daughter and son.
Whether that lady has got one more husband?
No, my lord.
But you are saying wife. Widow.
Yes, my lord.
Died. His widow and 2 children seek to come on record in the stead of the deceased to represent his estate. First off, copy of the application is served on the council representing the university and no objections are filed. First off, The panel council submits that he has already sent the application to the university and university's views are solicited. First up, however, court cannot wait for university to wake up from the slumber and come out with some explanation. Next paragraph. Ordinarily, applications of the kind are day in and day out allowed, subject to all just exceptions into which argued case of the petitioner does not fit. First up, in the above circumstances, application having been favored, the LRs of the deceased are permitted to be loaded to title of the petition to represent the estate of the deceased. First up, petitioner to amend the first title right now. Next.
Yes,
Item 42.
What is the matter relating to sanction of retirement benefits, such as unutilized leave salary? No notice was issued, they have not filed anything.
Here, my lord, so far the release of unutilized salary is concerned, that will file counter. But let me clarify, for a particular period, 131 days unutilized salary has been sanctioned. The rest claim is 169 days, my lord.
Yeah. For that, how many days permitted actually?
300 days.
300.
300 days. My lord, because
131, 169. It will be 300 only.
300.
Why 169?
That period, because of this was a holiday and it cannot be treated as unutilized leave salary, we will file the details counter, my lord.
Counter to be filed within 3 weeks, failing which petition amendment will be taken, which can bear value. Next.
When it will...
Let them file up things. Yes.
The date will be...
Yes.
Retired person.
Item 43.
Please, my lord. My prayer is, my lord, order dated 28/2025, had letter number 1863. Before my learned friend begins, my last occasion, my lord has directed to take instruction. So far, the present salary is concerned, it should be. Because salary, but let me clarify. Because he is from Abrampur, the highest distance here, my lord. In the meantime, my lord, I have received the order in WhatsApp. Release the salary from 14/9/2025 to 30/9/2025 and 13/10 to 13/10/2025. Recently, this has been paid, my lord.
Paid on which date?
This is dated 3rd December. Order, my lord.
Give him copy. Just look into. You may get your fee also out of that.
1 month salary. Only in the month of 2 months. 2 months. 9 months salary may be released. Other parts complied already.
1 month salary to be relieved.
Yes, ma'am.
Yes. Why the?
Not released. 2 months have been another 1 month I will take instruction because there is a communication gap. Day after tomorrow they are coming, my lord.
Day after tomorrow they are coming.
They are coming, my lord.
Day after tomorrow should you have the matter or you want some more time?
No, 1 week time.
1 week.
I don't pray for more time.
Perfect. That's a request of month. The submission that the only 1 month salary remains to be paid.
September, October paid.
Petitioner submission that only 1 month salary needs to be paid now. Now, the other amount having already been paid is placed on the card. Yeah. Item 44.
This is that matter.
Yeah.
Lordships had also asked us to stay together. We had sat together. He said that you were in some documents.
Documents are there. Case is that he was on principle, it was as approved by the recommending authority. Then for hotel, for establishment of hotel is an industry. For that purpose, this land was on approval. This is on principle is approval. And it is written that the allotment will be given in appropriate time. But that was cancelled. Why that was cancelled? Because the state government said that the master plan area in Bhubaneswar, Cuttack, Puri and Sambalpur. So in that area, it will be again reviewed and decided. Then it was reviewed by the high level committee. Why your lordship hear the matter? That last occasion, your lordship wanted to know what is the authority of that high level committee
and district single window clearance authority, all these things. But the scheme of the law is that.
You're arguing the matter now?
No.
What are you?
No. For that purpose, those documents your lordship required, I have bunch of documents I have brought. I can give him also the documents. I can give that. So on that basis, I can apprise your lordship. So if you want to,
your lordship will fix up a date so that I can go through the documents.
In the first week of January.
If possible, subject to your lordship's consideration, if possible,
The second
next
week
week.
of January 2020. 16, at the request of both the sides who want to come with more preparation. Okay.
Next. First week of January.
first week in court works only 2 weeks.
A second. No problem.
Yeah. Bit difficult.
I'm over.
Yeah.
Item 45.
In item 45, in response to my writ application, the government has filed a counter affidavit in the month of November, Lordship. If you should permit, I'll file a short reply as a rejoinder to that.
What is this matter about?
Yes, Your Lordship.
It was given in November.
My lords.
Affidavit was given in November to you.
Yes, Your Lordship.
24 matter.
Yes, Your Lordship. The matter is.
Do you genuinely try to file a counter to that?
A reply is required, Your Lordship.
The second week of, the third week of January at the request of.
Lordship, for Bipru Prasad Naik, one of the party in item 45, my learned senior counsel has now become the state counsel. He will not be able to continue with the case.
Who appears on his behalf?
Amitabh Pradhan.
Thank you. So it's permitted to retire and he's becoming the expert himself.
Item 46.
Lordship's kind permission, I appear through VC in this matter. Yes, I appear through VC. I'm sorry I couldn't remain present today, Lordship. This matter, Lordship, was before Lordship on the 30th of October, when a direction was given to the opposite party to file their response, which they have in the meanwhile.
In the meantime, it has already been filed since 26.
It has been filed. I've received it. If Lordship permits me, I am ready to argue the matter today. In fact, there is a note also on record. If Lordship has that note, it starts with a title of synopsis, date chart, and annexure page numbers. It's a very short note of about 4 pages.
Brother, since my health is not that good today, what I think is that you also be here. It becomes easy for interaction.
Very well, Lordship. No difficulty. Lordship, my only request would be then before vacation, because it's a critical matter. It's not a technical matter. It's just a matter which where I have to take Lordship through certain provisions of the Patent Act and the rules. And it's in essence, I will just tell Lordships in 2 minutes what the matter is. I'll just so that it's easier to recollect on the next occasion. Lordship, the matter is all about a patent having lapsed because of the negligence of my patent agents, for which I have come for a restoration. Now that is the sum and substance. As I argue, I'll show Lordships how this restoration can be allowed based on certain judgments which have been.
Restoration of a DC patent.
Seized patent, a patent that was granted which came to be seized due to non-payment of renewal fees by the patent agent. That is the sum and substance, but on the next date I will argue whenever Lordship fixes it. Lordship, any date, any earlier date?
Any rulings on that point? So that
there are about 5 judgments, and 2 of them are directly on the point, Lordship. They are also on record.
Which are they?
Lordship, my colleague, Mr. Marana, who is in court, who may give a copy. It's a 2022 SCC Online Delhi 5197 called Breyer Procon judgment.
Take notes of that and give me. Just brief me.
Yes.
All right. Call after 2 weeks. Yes.
Lordship, may I request for next week if any time, any of the days, I'll come down for this matter.
You have to travel from outside.
I have to travel from Mumbai, but that's not a difficulty, Lordship.
Okay. But if you travel from all the way from Mumbai to...
It's actually my client prefers that I come. Otherwise, I'm more than happy to conduct the matter through VC, but sometimes I have to come because the clients otherwise misunderstand. That is my only difficulty.
I'm sorry, my lord, just to interpret my lord. I'm sorry. My lord, this matter, admittedly, my lord, given chance, we cannot file the counter. So if my lord will fix after vacation, I will take my chance. Otherwise, lordship may proceed.
Lordship, I'll only say this. In fact, on the last date also, I
am very conscious. This is on 30/10/2025, my lord has given last chance. I am very conscious to that. That's why I am not approaching. Only I am approaching after vacation. If possible, then otherwise. Lordship, with this hearing.
We had given a warning to your client. Read the order.
I am absolutely accepting my lord's word.
Therefore, no time will be given to your client. Yes. Which will be convenient date for lawyer to come and argue. Give one date. 16. How many matters are posted?
9.
9 matters. Yes. Whether 16th is all right, brother, for you?
No difficulty, Lordship. In case, Lordship, I'm not able to come, I'll still be conducting on VC, but we'll finish the meeting.
Well.
I'm highly obliged.
Next.
Item 47.
Yes.
3 persons similarly placed, a very small issue. They have been continuing on contractual, sometimes guest faculty in the university. From 2003, somebody was from 2012, for long days, my lord. It is subject to renewal and we have been renewed and we have been allowed to continue as assistant professor, having the requisite qualification. All are PhD holders and all these qualifications they have. Now, what they have done, the university only to get rid of us, they have issued a fresh advertisement because and force us to participate. At that juncture, we came before this honorable court, my lord, the law with the limited, that is why I have stated this is a limited law, that one set of contractual employee cannot be replaced by another contractual employee. That is why my lord have protected, keep one post of...
Who is for the university?
My lord senior is there.
You are ready?
Yes. This is the only point. Only 3 documents.
Whether you are going to have another set of contract employees?
Yes.
Well, there may be the different number of posts. It's a self-financing scheme, madam. Under the self-financing, the first one is 2013, thereafter 2007. There is no regular department, there is no regular sanction post. So it's only a self-financing scheme for which a different there, walk-in interview. Some of them, sometimes they were appointed as guest faculty, sometime on a temporary basis for one year period. And guest faculty, all periods are limited. The appointment orders were there and they accepted that. Now, in the meanwhile, they have issued, which has been stated, my lord, which is for guest faculty interview, walk-in interview there. If I require, they say that they cannot be replaced. Maybe that can be protected. But supposing I require 2-3 posts, 2-3 lecturers, that one post may be for them, but others can be also appointed.
That is the order. That is the order. Like, kindly see the interim order, my lord. Sorry.
So fairly he is saying.
No, but probably my senior has not read that. That is why I am saying.
No.
What he is suggesting is keep one post. That only one post is reserved, other posts are released. They have appointed persons. That is the
now. I am asking a question to you. They are one set of people. Apex Court has said, subject to 3 exceptions. You cannot substitute one set of people by another set. That is the gist of this case. Unless you bring your case within the parameters of one of the 3 exceptions. I do not find like that. Are you going to disrupt them?
It's a fresh interview that we have called for. And they say, admittedly, they have no problem. They will be engaged. In your lordship,
they can record and dispose of the matter.
Let them engage us. But they are not allowing us, my lord.
If they are not allowing, it's another thing.
Yes. If the scheme, supposing there will be no students
for the self-financing scheme. We can't.
Then they go.
They go.
But you can, on that ground, you cannot bring other people.
No.
In this case.
If supposing 2-3 posts are required, he may be protected. So far as the contractual appointment is there. But 2 more can be taken in if subject to all.
Without disturbing them, take another 100.
Yes, that's it. You also may say that.
Okay. The short grievance of the petitioners is that they are in all probability be substituted by another set of guest lecturers, which fact is probabilized by the issuance of notification dated 8/2024, which this court had stayed.
That is not been stayed. That court has said only one post will be reserved for us.
First. Learned counsel for the petitioners submits that it has long been settled by the apex court decisions that one set of ad hoc employees cannot be substituted by another, subject to all just exceptions into which argued case of the university does not. First. Next. Learned senior panel counsel appearing for the university very fairly submits that there is no such case of substituting the petitioners as of now, and that if there are more hands required, the existing hands cannot prevent the entry of new hands. Their apple cards or card is not disturbed. First, with this proposal, counsel for the petitioner is also a First, thus the projected list withers away in thin air. First, in the above circumstances, this writ petition is disposed of, restraining the respondents from substituting the petitioners by other set of similar employees. First. No first. Next.
You may pray only one indulgence. In fact, after I file this case, they are allowing others to continue, but they are not allowing us to continue. I'll take note of this.
The university shall implement this order by permitting the petitioner to work in its employment as before, without unnecessarily risking itself the contempt proceedings.
All the 3 are same, madam. All the 3 cases, same.
Instead of ad hoc employee, you lordship may say they are under the self-financing scheme.
That is there. That I will clarify if you are
self-financing
scheme. They are under the self-financing scheme.
Employees under the self-financing.
That is admitted. Yes, ma'am.
That way, actually. Okay, next.
Item 48.
Also, kindly see my lord's order dated 17/10/25.
17/10/25.
Order number 4.
Salary is payable.
No, they have not paid, my lord.
They have not paid. Who should pay?
District Education Officer, my lord. 3 and 4, my lord.
3 and 4.
Director also. 2. Opposite but note 2 will pay.
Yes, Mr. G.
My lord. We have filed our counters here.
Before or after the order?
It was filed on 17/2/2025.
When the order was made?
The order was made
subsequent. 17/10/2025.
17/10/25.
Ask your clients to be personally present before the court. If they come, well and good. Otherwise, I will direct the police to produce them before the court.
My lord, they will come, no problem. But the order.
Why they have not complied with the order? If they come, what I should do? I should send them to some other place. Why your officers are not obeying the court orders?
On 1710, my lord, my record speaks some other orders were passed. But let's say, give me a chance so that.
Last occasion
On 17/10/2025, this court had said as first, the said order has not been complied with. First one. Court is unhappy with this. First. Next one. On the next date of hearing, OP numbers OP number 2 shall be personally present before the court to offer explanation as to why that order has not been complied with. First one. However, his presence and explanation would not be clear if in the meanwhile order is complied with. Okay. Good. Next. Call this matter on Thursday. How many days? Next week?
Next week,
Monday.
thereafter 22nd, my lord.
No, not so much time. I will not give so much time. 2 days, 3 days. Otherwise, I will direct their arrest and detention. I will put them in the courtroom here. I will get one courtroom vacated by the Honorable Chief Justice. I request him to keep one room present, completely vacant for me to place all unscrupulous fellows in that room. I am not happy.
My lord,
Monday, I will call this matter.
Monday, my lord, it may be on 17th.
17th. Sorry. The failure to comply may result into an order for arrest and detention. Okay.
Can I pray, my lord, order dated 1710?
Yes,
25 copy may be given so that.
Share a carbon copy of this order.
It is there with them.
No, this order also. This order. So tell them, somehow I'm waiting for some push to put some people in the place.
No, I have
not getting actually.
I have communicated that, my lord.
This is not the way that citizens should be treated. Even during Mughal rule, it was not like that. Yes.
Item 49.
May I please, Your Honor? Well, the issue is simple. One reduction list was issued. That was passed by the Hon'Ble Court because that was contrary to the rules and the government instructions. It was 20%. They, without recasting the reduction list, they continued to give promotion based on that reduction list. Old rule. And rule in terms of rule, my lord, the collector is the chairman of the committee. But the DO, my lord, sitting himself, taking himself as the chairman, asked orders and allowed promotion to private opposition. That is the sole reason.
You appear for
no one. I am on this with second matter.
Yes, Mr. G. These things happen. I used to read in primary school. The Alice Wonderland. Only in such things, these things used to happen. Where the gradation list is at a time. Except in 1 or 2 exceptions. The quashed gradation list is operated.
Yes.
But not here. Number one.
Lordship.
Who is the BE to assume the arrogate to himself the power of the district collector?
No. It is the under the rules the district collector.
District collector has to do that. That's the only point.
That is the only point.
Lordship wanted some instruction on 30th of October.
No, you also state that beyond 20%, it was made them 10%. That's you also protected me saying that 20 was there. They are in that 20% category.
What instruction?
You want instructions?
My lord. Why he has done that? On exercising which power he has done this?
See, rule says.
Rule says the district collector, my lord.
Who is he to arrogate to himself the powers of the district collector?
My lord, yes.
In why district collector is silent?
That also.
When his or her powers are usurped by others, why that usurpation is permitted? So action should be taken both against the thief and the thieved. Any counter is filed?
Yes, counter is rejoinder, everything is filed. Let's see. I want that instruction, my lord, so that.
Will to that?
My lord, yes.
At the request of Mr. Chief.
The interim order that
Interim order to continue.
Both the matters.
Both the matter. Then 16th not possible. 22nd. Yes.
Item 50. Item 50, my lord. 2 weeks time may be granted for filing rejoinder, my lord.
First week or second week or third week of January for filing rejoinder at the request of.
Item 51.
Good. Input order is annexure 7. The house rent, my lord, the question of house rent has to whether the petitioner is eligible to get 8% of house rent, my lord. House rent allowance.
Yes, I heard this matter.
Yes, your lordship had.
You were reading some exception to this general rule. The distance.
Only the distance.
Distance is the factor.
I am within that distance, my lord. I am residing in my house is also the municipality area, my lord. That is, I have all annexed everything, my lord. Your lordship can see the annexure 1, 11.
This is dated 14/3/24.
My lord.
This is by whom?
This is the government, my lord, the circular. Circular is the principal secretary of government, right?
It says what?
If you lordship can see the
3 class. Municipal Corporation, Bhubaneswar, Behrampur, Cuttack, Rourkela.
I am coming under 3. Serial 3, man.
8%.
Jagat Singhpur, 8%, man.
Are you residing in this area?
Yes, ma'am. I am residing within 8. I am residing, my lord, the Jagat municipality, my lord. The rejection ground is, my lord. My school is in a rural area, which is within 8 kilometers exactly from the
where he is serving.
Serving, my lord, that is a rural area.
Where he is
within 8 kilometers.
The school is in a village.
School is not the factor.
No,
because he does not reside near the. Beside the
he is to reside there. The counter is, my lord, paragraph 8. I had written. The opposite party number 3, the DO, has disposed of the representation dated 28/9/2024 of the petitioner by rejecting the prayer made by the made in the representation for entitlement of revised HRA at the rate of 8% of the basic pay instead of 4%, as the petitioner's headquarters is Samanga, where he is working in rural area. The same is based on the letter of the government in the finance department memorandum dated 14/3/2024. Xerox copy of the letter dated of the DO at annexure AY3. As per finance department memorandum dated 14/3/2024, the finance department have revised HRA. Employees residing in district headquarters municipality of Jagatsinghpur to 8% of the basic pay. Paradip municipality 12% of the basic pay. In other areas 4% of the basic pay. Those who are residing there, the institution is there. They have to reside at the place of their service. Suppose somebody is staying, somebody is working in a rural place of Cuttack, but is staying here. Will he entitled for the house rent available meant for the employees of Cuttack city? No. He is entitled for the HRA of the school, where the school is situated.
nowhere stated so, my lord. Lordship can see the annexure 1, page 11. 1 second, my lord. The 3A, my lord. 3A, serial 3A. The rate of house rent allowance would be applicable shall determine according to the place in which the headquarters of the government employee is located. Headquarters the government article just one, however, a government employee is staying in a hired accommodation, living in his own house. I am residing in own house, my lord. Within 8 kilometers of headquarters shall be eligible to the house rent allowance. I am residing in my own house, my lord, which is within 8 kilometers, which is 6 kilometers from my headquarters, my lord. The second thing, well, the urban headquarters, government employees staying in the hired accommodation, own house, either within the radius of 8 kilometers of headquarters or the limited urban local body, municipal corporation, municipality, and notified area council, as per EMDW.
What is meant by headquarters? Who is the headquarters?
Headquarters means the place of work.
Place of work. That's what.
But I am residing in my own house that is within 8 kilometers.
Suppose if your house is elsewhere, that makes no sense. Tomorrow, the object is not that. Object is something else. Headquarters means not dictionary headquarters.
I am annexing other documents, my lord.
Where they have given to others.
Other documents, that is all the offices are in rural area, my lord. They are also getting the some benefit, my lord. That lord, you can see the annexure 2, page 16. I am giving the.
What is your explanation to others, Mr. G? Which he said to others you have given. Why not to him is his contention? How you have countered that contention?
No, we have not countered that, my lord.
Then that amounts to admission only. You can't have interpretation of a particular circular in one way for one set of people and the other way for other.
No, it is not that, my lord. To that effect, my lord. Who is staying where? बतौना देखिए क्या रोई जाते
कौन ये तुमने horticulture office the rural area
you explain that, my lord. Just explanation from your clients and then counsel for the petitioner asserts that to the similarly circumstanced people house rent allowance has been
of different
department. 8% has been given. No, but that makes no difference actually. 8% of the basic is paid by way of house rent allowance, whereas his client has been discriminated. First off, this aspect has not been dealt with in the counter filed with the OPs. First off, learned AGA, Mr. G seeks a short accommodation to have conference with his clients and come back. Call this matter on Saturday.
Lordship's permission, my lord. That averment I have taken in my paragraph 6.
That's next.
Item 52.
Mr. G, there cannot be two standards.
No, never, my lord. One for all.
May I be permitted to place these things? My lord, before I start, my lord, I should apology that there is a...
Before starting only apology?
Because there is a typographical error.
Which one?
Which is available in the prayer portion where instead of annexure 6, which I actually impugned, it has been mentioned as annexure 7.
So we'll read it as annexure.
Yes, that is what I say. My lord. And here is a case, my lord, which relates to regularization of a service of a teacher, lady teacher, who has been made victim of circumstances because of the wrong committed by the authorities, and ultimately his regularization is being denied by perpetrating the illegality committed by them.
When she was appointed?
My lord, she was initially appointed.
Engaged, he was not appointed.
She was
engaged. I meant
yes, that much. But she was, well, as per the government scheme prevalent then, she was appointed way back in 1992.
1992.
Sorry, way back in 1998. Sorry, 1998. Sorry, 1998.
98 calendar has any month, day, etc.
On 3/12/1998, I have given my appointment order itself, engagement order itself.
3/12?
1998, which your lordship gets at running page 14.
3/12/98.
May I draw your lordship's attention to running page 14?
Annexure 1.
Yes, ma'am. Annexure 1. So I was as non-formal education facilitator. Non-formal instructor, your lordship.
Non-formal instructor.
Instructor. And that was issued, your lordship kindly marked, by the District Inspector of Schools, Hon'Ble. Yes. So she was appointed as a non-formal instructor way back in 1998.
How long she continued?
She continued there till that scheme was abolished way back in 2000.
See, 3/12/98 is like 99 only.
My lord,
only 1 year she has.
There, my lord, there is the facts are not disputed. That is why I am saying, my lord. So after that abolition of that scheme, she was disengaged just like others. And my lord, government brought out a scheme for observing those retrenched the educational volunteers in EGS centers.
Where is that?
Yes, my lord, your lordship may kindly see, and as a result of which, way back in 2003, the petitioner was regularized, was appointed as a EV.
2003. No date, no calculation.
Appointed as EV.
EV means?
Education volunteer.
On which date?
On 18/3/2003.
The disengagement happened which date? 3/12/98 was engagement.
Yes. Disengagement happened with the court organized with that scheme way back in 2001.
Why you are so much shying on dates and months?
My lord,
since you have taken a Bhishma Pratigna not to tell the date and month, no issue, no problem.
No. That is there, paragraph 4.
I'm asking the dates.
1/4/2001.
Then engaged as EV. On.
In 2003.
27/7/2003.
27/7/2003.
Under EGS centers.
Under Sorisada, the Jenasai EGS center.
Under?
At Sorisada Jenasai EGS center.
Where is that sentence? Which document?
My lord may kindly come to one document which will suffice, because the collector has caused an inquiry. Thereafter, I was given justice. Page 9, Annexure 4, running page 19. With the direction of the Honorable Court, ultimately the collector came to my rescue and passed this inquiry report. Your lords may kindly come to running page 19. Paragraph 2 onwards. Shall I read, ma'am?
Yes.
Whereas the EGS center in Sorisada Jenasari EGS center in Ali block of Kendrapada district was upgraded to new primary school, upper primary school, due to closure of the scheme. I was appointed in the very same EGS center, which was again upgraded to a regular primary school, which led to my termination once again. Whereas the petitioner Srimati Sandharani Mishra was working as EV in Sorisada Jenasai EGS center under Ali block of Kendrapada district. Now she has prayed for engagement of as Ganasikhyak as per the government guideline dated 5/4/2008 in the EVs of the EGS center, whose name will be approved by the district EGS committee under the chairmanship of the collector, and she was disengaged due to upgradation of EGS center to new primary school / new upper primary school. Whereas Srimati Mishra was working as EV in the said center until the date of closure. Whereas Srimati Mishra is entitled to be engaged as Gana Shikshak as per the letter mentioned supra.
So he recommended for absorption.
My lord, here, my lord, your lords may kindly mark, by the resolution of the government dated 5/4/2008, which has I have read before your lordships, government has brought out a scheme for observing these education volunteers under the old scheme who faced termination on account of upgradation of the very same centers into the project primary schools as Gana Shikshaks. So 3 terms, my lord, with lordship's my lord permission, I am saying initially appointed as non-formal instructor, thereafter appointed as EV, and again I was supposed to be appointed as Gana Shikshak way back in 2008. This appointment of Gana Shikshak of the year 2008, to which I claim that was denied to me by the authorities till the collector upon the intervention of this honorable court came to this finding that on the date of closure I was there. So I was also eligible to be appointed as Gana Shikshak, which was denied to me. So that has led to a situation. This inquiry report was ultimately accepted. This inquiry report was prepared on 9/1/2019 and in effect to by issuing appointment orders in my favor on 28/2/2020. So my entitlement, to which the authority have now ultimately found out of the year 2008, has ultimately been made available to me by issuance of the very same order of engagement as Gana Shikshak in the year 28/2/2020. Similarly placed persons like me who were working as EV then, who were regularly appointed as Gana Shikshaks way back in 2008. So this illegality, which was committed by the authority for no fault of mine, ultimately made me to lose the benefits which others are getting all these years, and to which I am now placing before your lordships with a prayer for grant of the same benefit of regularization, unlike my counterparts who were appointed way back in Gana Shikshak when I was also eligible but denied. And this is sum and substance of my case. And in between, what has happened, my lord, I am a person who is having B.Ed qualification to my credit. So you became B.Ed when? I became B.Ed in the year 2011. In the year 2011, I became B.Ed. But I was having the graduation qualifications then, and for appointment as EV and the non-formal facilitators, my lord, the
B.Ed is not required.
It was not the requirement. Since, my lord, now the Gana Shikshak post is also not there, and government has given them the appointments and as level the V teacher bracket X cadre, level V bracket X cadre, that benefit is being denied to me, even if government has discontinued this engagement of contractual engagements since 2022 by rules. So that nowadays under the government, not a single person is being appointed initially as a contractual staff in any form of employment.
It is stopped.
It has been stopped. And all those persons who were appointed prior to that have been taken care, their interests have been taken care of, then they have been regularized into regular.
All right. What is that you want at the hands of this court?
So, my lord, now, my lord, my claim is I must be regularized from the date to which I was entitled to, and the collector, after causing an inquiry on being intervened by this honorable court, has found the same to be that I have been wronged by the authority. And initially, for your, my lord, initially the authorities were saying that on the date of this schools were upgraded way back in 2008, I was not there in service. On that ground, My lord, this is the fourth round of litigation I am fighting out before your lordships. My engagement was all through objected to, saying that you were not continuing when the school was upgraded. That is why you are ineligible to be taken in as Ganashikya.
That were earlier rounds of litigation cases.
Yes, my lord. Your lords may kindly come to
WP.
I'm
Just tell me the WP.
Yes, my lord. My lord, one WP is 18,440 of 2013. 18,440 of 2013. Whose order, my lord, I have enclosed as I have quoted at disposed of on 4/5/2016. Where the collector was directed to cause an inquiry. And my lord, another writ petition, that is WPC number 24204 of 2021. That was filed after my engagement was, after they engaged me pursuant to the order passed by the collector, the inquiry report given by the collector, the government accepted that and given me appointment on 28/2/2020. I approached this Hon'Ble Court with a prayer that since others were granted with the same benefit, my regularization may be made antedated from the date the counterpart, the other counterpart.
What the court said?
The court directed them to consider my representation.
Dated?
Well, the order of the Hon'Ble Court is dated 1/9/2021.
Then another is?
And after this order was passed, my lord, DPC, District Project Coordinator, Sarva Shiksha Abhijan, he rejected it. The District Project Coordinator, SSA, rejected it. That became the cause of action. That became the cause of action to approach this Hon'Ble Court again in WPC number 11,134 of 2023.
There it was said as?
There, my lord, the matter was directed to the secretary for consideration because DPC is at the project level. So this Hon'Ble Court thought it appropriate to direct the
18/4/2023.
Yes, my lord. 18/4/2023. So there, my lord, after this order was passed by, after this direction was given by this Hon'Ble Court, the present impugned order under Annexure 6 has come.
What this order says?
This order, my lord, is on two grounds. My prayer for this retrospective regularization has been rejected on two grounds. One, since I was appointed in the year 2020, the regularization cut-off date, whatever the authority has taken in, my lord, since my appointment was after that, so I cannot be given the benefit of that one. Second thing, I had not put in 8 years of experience as Ganashikya so as to make me eligible. Here my humble submission before lordships, because of the apathy of the authority, because of the wrong committed by them,
you were prevented from
discharging my duty. Had they not been treated me unfairly, unlike my counterparts, I would also have been regularized as Ganashikya way back in 2008. So
essentially your case was for antedating of regularization.
Exactly. That is my prayer.
They say you are not entitled to because you accepted that appointment order.
Yes.
Number two, they say you did not put in 8 years of required service.
Yes. Number three, my lord, what they say, since that the rejection order itself says that at the ground, it is my duty to bring it to a lordship's notice. The third point which they say is, I have not acquired that OTET qualification. And my lord, this Hon'Ble Court, my lord, this requirement of having OTET qualification has been deprecated by this Hon'Ble Court, being
not a requirement.
Not a requirement for this. That is the judgment while I have annexed.
Balabhadra Majhi's case.
Balabhadra Majhi's case.
This court.
Next question.
Only.
If you permit him, he will also say a few words.
Sorry, my lord. Only in Balabhadra Maji's case, my lord, was passed, basing on the or some orders passed by the government. Those who have not qualified OTET, only some increments they will not get. Increments they will not get. To that extent.
For regularization, it is irrelevant.
It is irrelevant. But the Supreme Court nowadays have make it mandatory.
Mandatory for what?
Mandatory for regularization or for all the primary school teachers will acquire OTET.
When it was?
It was from the beginning, my lord.
Beginning means when the earth took birth.
My lord, yes, my lord. From the all the teachers, my lord. It is not that.
You only say that Balabhadra
Maji.
Say it is relevant only for the earning of increments, additional pay benefits, etc.
Yes, only increment, only increment.
Yeah, but how can you make use of that for appointment, regularization, etc.?
Balabhadra Maji's case is that, my lord. But so far as that Supreme Court's judgment is concerned, it speaks something.
OTET.
OTET.
Only three.
Teachers eligibility test. My lord, in Balabhadra Maji's case, my lord, if a lordship permits, my lord, I can submit because my learned friend is.
It is there. I have annexure. It is.
My lord, in Balabhadra Maji's case, this honorable court has interpreted the circular issued by them and the condition available therein itself.
In the year 2000.
In fact, circular where they have issued for regularization, it says those who fail to acquire this OTET qualification, in respect of them, only they will not be eligible for grant of future increment.
Increment, sorry.
So that is what this honorable court did.
The essential grievance of the petitioner is as to denial of antedating of his regularization on three grounds. Number one, several litigations having taken place at the instance of the petitioner, petitioner accepted his her appointment, and as such, she cannot claim anything beyond that. Number two, petitioner has not put in 8 years of service as Ganashikshak.
Yes, as Ganashikshak.
And three, petitioner lacked OTET, which is a precondition for appointment. Next one. Learned from the petitioner in his usual vehemence submits that petitioner was before this court in WP number 18440 of 2013, disposed of by a coordinate bench on 4/5/2016, whereby the Deputy District Collector was directed to hold inquiry into the grievance of the petitioner. That inquiry proved fruitful to her. She had filed WP 24204 of 2021 that was disposed of by another coordinate bench of this court by order dated 1/9/2021, wherein the consideration of petitioner's grievance was directed at the hands of the secretary. You said something like that?
No, DPC.
At the hands of the DPC, which eventually went against her. First, that led to petitioner filing WP 1134 of 2023, which was disposed of on 18/4/2023 by yet another bench, remanding the matter for fresh consideration at the hands of Secretary of the department concerned. First, he submitted that. Kindly be seated. You can answer sitting only. He submits that when the deputy district collector in her report dated 9/1/2015,
9/1/19, my lord.
9/1/2019,
page 19 of the brief,
had specifically favored claim of the petitioner, finding fault with the version of the officers, the full benefit of the said order ought to have been given to his client. First, denial of such a benefit virtually prevented the petitioner from putting in 8 years of service, and therefore the authorities cannot take the benefit of their own wrong to the prejudice of the citizen. First, lastly, he submits that whatever order has been issued to her was not the end of the matter, she having been fighting the legal battle one after another, the ground assigned in the impugned order is unsustainable. First, lastly, the requirement of OTAT is only fictional. In Balabhadra Maji, give full citation. It has the same having been explained that such a qualification is required for earning certain financial benefits like increments, etc., and not for appointment. First. Next one. Learned AGA representing the OPs has filed the counter resisting the writ petition, taking up contentions consistent with those mentioned in the impugned order itself. First, they make submission in justification of the grounds on which the impugned order has been structured. First, so G also tells the court that there are certain decisions of the apex court wherein OTAT has been recognized as a requirement for the appointment as well, and therefore the impugned order is unassailable. First, so contending, he seeks dismissal of the petition. Next, having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one, petitioner was initially engaged as a non-formal instructor by order dated 3/12/1998, and thereafter she was disengaged with effect from 1/4/2001. And that she was engaged as a EV. EV means
Educational volunteer.
Educational volunteer with effect from 27/7/2003. Comma, or not in dispute. Petitioner had fought a slew of legal battles, particulars of which have been given above, is also not in dispute. Therefore, that the petitioner accepted the order that was founded on the Deputy Commissioner's report, followed by other actions, cannot come in the way of petitioner ventilating her complaint in the its jurisdiction. First, to the same extent, the ground urged, stated in the impugned order is unsustainable. Next paragraph. Learned counsel for the petitioner is right in drawing attention of the court to the district collector's inquiry order dated 4/5/2000. Order dated
9/1. That is Annex 4. That is 9/1/2019. Page 19. At the
9/1/2019. Whatever it comes.
Page 19 and 9/1/19 at the top.
Whatever it comes. Attention of the court.
My lord, I may be wrong, my lord. That is, inquiry report is dated 31/1/2019 in pursuance of government's order dated 9/1/19. First paragraph, third line.
Inquiry report dated.
Inquiry on 31/1/19.
31/1/19. 1990. At the form.
Yes, please.
Form. Which in the last 3 paragraphs reads as under page 20. Mark that 3 paragraphs, page 20, yellow mark, all the 3 paragraphs. Full. No, not that. This one.
Will your lordship add something in his submission? It will help him probably. Lordship may kindly have a look to annexure 2, page 15.
What is that?
The resolution dated 16/2/2008. First paragraph. For the purpose of universalization of the elementary education, the Education Guarantee Scheme, that is EGS, an integral part of Sarva Shiksha Abhiyan, was operationalized in Odisha to 2001-2 due to upgradation of EGS centers to regular schools and for various reasons. The education volunteers engaged in such EGS centers have been disengaged and would be facing disengagement above process. My lord, those
thereafter, government after careful consideration.
Government after
careful consideration of the problems of the education volunteers under the EGS scheme decided to rehabilitate volunteers in EGS centers who have been disengaged or
facing disengagement
under the EGS scheme on the following manner. First is very important. Yes. Such disengaged education volunteers will be rehabilitated as
Gana Shikshak.
Yes.
Next paragraph.
It will be
counsel for the petitioner is also right in drawing attention of the court to the government resolution number 3358 SME dated 16/2/2008 at Annex 2, wherein paragraphs, unnumbered paragraphs 1, 2, I condition them.
My Lord, may also
do also.
My Lord, may 11 also. 11 is very important. From which date it will be given effect to? The Ganak Shikshaks will continue to avail the benefits in the process of selection. Had office order dated 4/11/2007.
Page 15. In that paragraph 1, paragraph 1. No, unnumbered paragraph from the beginning. Make it yellow. Which resolution, which reads as under. First of all, the said resolution specifically provides for engagement of education volunteers who have been disengaged as Gana Shikshak.
It is disengaged
under Sarva Shiksha Abhijan. First, paragraph 11, which is already reproduced above, specifically states that the Gana Shikshak will continue to avail of the benefits in the process of selection for engagement at Shiksha Sahayak as extended in the government in schools and mass education department of peace order dated 4/12/2007. First, this aspect has been conveniently lost sight of in the impugned order. First, next paragraph. Learned counsel for the petitioner is right in telling the court that when an employee is prevented from putting in number of services as required under the policy, for no fault of hers, the benefit otherwise available to such employee cannot be denied. First, a contra argument would amount to permitting the erring official to take the benefit of their own error to the disadvantage of the citizen. First. Lastly, the requirement of OTAT has been put to rest in Balabhadra Machi.
Annexure 7.
A copy whereof avails at Annexure 7.
Page 20.
That is
Page 20.
WPC 15346 of
345.
15345 2022. This code of a coordinate bench of this court with order dated 11/11/2022. First, the impugned order having been structured contrary to the law declared by a coordinate bench of this court as error of great magnitude apparent on its face and therefore becomes vulnerable for challenge. Next paragraph. In the above circumstances, this petition succeeds. A writ of certiorari issues quashing the impugned order. A writ of mandamus issues directing OP numbers.
OP number 1.
OP number 1.
1 and you may kindly see also 3. Because 3 is the...
3 is a subordinate or
subordinate. 1 is... 3 is collector. 3 is collector and...
should take the decision.
But this has to be taken by the government, both, because
It's not both.
as well as. You also say one.
OP number one.
One.
OP number one. To grant, which date to be granted, the date of regularization?
2008. From 2008.
You are not about, never you will say the month.
Sorry. Well, from the date of resolution, 16 to 2008.
To treat petitioner as having been granted regularization with effect from
2016 to 2008.
To 2008. That is the date of resolution number 3358 for SME. And to grant all consequential benefits within a period of 3 months.
As level V teacher, consequential benefits as level V teacher.
First, while doing this, the status of the petitioner shall be level
V ex-cadre teacher.
V.
V for victory.
Victory. V teacher.
V ex-cadre teacher.
Level V ex-cadre teacher.
Within bracket ex-cadre.
All right. Delay shall be waived. Very serious. Costs reluctantly made easy.
Time period maybe
3 months.
Oh, diploma.
Let's see if we need any clarification. You can have that. Yes.
Item 53. Item 53, my lords. There are two writ applications pending. One relates to the company being blacklisted and one relates to the directors. My lords, we are only pressing the interim order for the directors today, my lords. Your lordships wanted to know the entire jurisprudence vis-a-vis blacklisting of
company and its directors.
And its directors, my lords. My entire case, insofar as the directors are concerned, my lords, that no show cause was given to us. A show cause has been issued to the company. There is no dispute regarding that. The company has also replied that is going on, my lords. Your lordships will hear the matter that is pending before your lordships. Insofar as the directors are concerned, my lords, even if, as I have said on the last occasion, your lordship lifts the corporate veil, still then, my lords, the directors, my lords, if they are going to be blacklisted, my lords, they cannot be blacklisted being unheard. They have to be served a show cause notice and they have to, for example, I gave your lordships an example.
Once invoke doctrine of lifting the weight.
Corporate
veil. When whatever is done to the company is done to the directors.
It will appear in a show cause notice to the directors, my lords. That is exactly what the Supreme Court says, my lords. It goes on, my lords. I'm giving your lordships the entire jurisprudence, my lords, starting from 75 to 2025, my lords. How blacklisting should take place, my lords. In fact, they have gone
75 Justice Krishna judgment.
No, my lord, this is A.N. Roy, KK Matthew, my lords, Eurasian Equipment and Chemicals Limited versus State of West Bengal, my lords. This is the first judgment on the subject.
This may be provided to us.
Yes, certainly I will provide the entire list.
Yes.
I'll provide the entire list. Internal copies.
Are you ready in the matter?
I see that there's a bulk of judgments. So if he shares it, only the list we will get it. But like this, I may not be ready with all these judgments.
No, the simple principle which has been laid down, my lords, is anyone who is being blacklisted has to be given an opportunity of hearing, my lords, in so far as the blacklisting is concerned, my lords. No. In fact,
correct question will be, I will articulate for you. Whether opportunity of hearing to the company,
my lords, would tantamount to opportunity of hearing to the directors. My lords, what I am saying is, my lords, directors, as your lordship is aware, my lords, directors are separate entities from the company, my lords.
No, that is for Solomon or Solomon is for some other purpose.
But if your lordship kindly sees their blacklisting, my lords, the show cause.
Who answered the show cause notice? Which director?
My lords, I'll go prior to that. Against whom the show cause notice was issued? Show cause notice was issued. If your lordship kindly sees page
in Cox and King, nothing is stated.
Yes. Para 90 of Cox and Kings, the integrity pact with the company says the principal as well as its family members. Now petition number 1 and 2 are family, father and son.
My lords, annexure
they have answered. The communication is signed by the directors.
Maybe, my lords. One of the directors might have signed it. There are a number of directors. This is a public limited company, my lords. And there are a number of directors. There are nominee directors
Which
also.
directors are before this court?
All the directors.
All the directors?
Yes, my lords. Your lordship kindly says annexure 6. This is issued to Bhilai Engineering Corporation Limited. Directly to the company. Now, show cause notice has been issued. We have replied.
How courts have treated this question?
This question, my lords, there is no such question which has been answered, but the relevant portion which has been answered by the apex court all along, my lords, is that anyone who is being blacklisted
has too general a proposition. Anyone means,
yes,
whether company includes directors, that question is treated.
My lords, that sort of a question has never arisen, my lords. That question has never arisen. We have checked up the English law also, my lords. This sort of a question, my entire argument is, my lords, your lordship is aware of Solomon versus Solomon, where the company is a distinct authority from that of the directors. Directors are separate individual entities. So a show cause is necessary to them in order for an effective order of blacklisting.
Aspect. This idea I am getting from Idea of Justice by Amartya Sen and John Rawls' Theory of Justice. I can go into all these arguments. I can write a good judgment. It's another subject to appeal and other things. Suppose if I'm just exploring what Idea of Justice says. Amartya Sen has said, now give an opportunity of hearing, take a first decision. Exactly. I'm just putting it, I'm thinking aloud. What would be its repercussions? How that will affect you? It is more like Maneka, post-decisional hearing. Maneka Gandhi versus Indian North India.
Maneka Gandhi is also in Madhyamam, my lords.
Yes, but
they say audio alterum partem is a constitutionalizing this principle, my lords. That is all we are doing.
We can put at least one case but to the other realm. You take a decision. You give them opportunity of hearing. I will take a decision. I will dispose of this matters. I will keep open all contentions. Whatever contentions they want to take, you take it. Instead of me saying all those things. I am told Cox and King is also being reconsidered. So best way is you give an opportunity of hearing. It is a post-decisional hearing. We'll make it clear and decide it. I'll keep open all contentions. Why do you push me to decide the larger issues when it can be? We need not take a sledgehammer at all.
There are two writs, if I can say.
No, one writ we have to keep it apart, we have to hear it separately.
No, on the last occasion, the understanding is that both the matters would be heard by
this idea
totally get your lordship.
Has struck to me instantly.
So then, my lords, the first writ has to be
segregated.
Then keeping that writ pending,
yes,
and directors only being heard, that would
do that.
No, then my lord, the order, if my lord does that, then the order of banning would be then set aside or remitted.
Yes, only that.
Then, my lords, here there would be 2-3 important documents. The petitioners who are before
you. No, you take, these are all inputs for taking a decision.
No, they were heard. The
petitioners were heard as directors. They were representing the company. So the hearing to them was hearing the company. Now they say, you have to hear me. Instead of wasting our time, in a short way, provided both of you agree. Otherwise, I'll impose my order on you.
No, brother. What I was humbly submitting methods is that let the first writ be disposed of on merit.
That's how.
That means the company's matter is there. That cannot.
No, I keep separate. Right?
That can be disposed of with this. So far as directors, what falls from your lordships, that can be considered.
No, the second one.
The second one, the first one has to be heard.
Both can, what I was submitting, your lordship can dispose of both. Let them succeed. In the first matter, they have absolutely nothing. It's a fraud of bank guarantee.
Well,
now, my lord knows.
They want to argue, we do not know. Therefore, I will not couple this. These I don't want to couple them.
If my lord, there is
nothing will happen. Now, suppose I'm just thinking, this case it has happened or not, I don't know. Mr. Palkiwala was the director of ACC. Assume ACC is blacklisted. What impact Mr. Palkiwala will have? Because he was chairman of ACC also.
Exactly.
Associated group of companies. I'm just thinking that way. Suppose if I'm a director in a company and company is stigmatized, that stigma will put its shadow on the directors also. Therefore, hear them, decide afresh. I will keep open, entire basket is kept open. Whatever you want to put into, whatever you want to take out, do that exercise. Be fair, adopt a fair procedure, decide. And if they are agreed, they will come back here. If they are happy with your this one, well and good.
Our only problem is that these are all relatives. It's not that these are independent.
And I will say, whatever is being done under this order shall not cast a shadow on the pending matter. A judge who will hear that matter will not look into this order.
My lord, my call is next week. Let me just find out what. Let me call this next.
Call Monday. At the request of oblige. No decision of any High Court.
I understand, balance. Nothing. That is all we are praying. I'm deeply obliged.
Monday can be have it on Tuesday.
Tuesday.
Item 54.
Deeply.
My amendment petition is pending.
Two objection before your lordships. One is PET, another is Sanskrit. Both these subjects were segregated in this PUF. It should be segregated from one another so that it will be easier to decide the list.
Which to be segregated from which?
That item number 3. The serial number 31572 by 2025.
This is
that is to be segregated.
31572 of 25. That will be segregated.
31572 of 25.
Segregated, but this is also to be taken up, my lord, in the interim order. You were selected when you are not getting appointment.
Second one is Sanskrit.
All others are, I think, Sanskrit.
First and second is Sanskrit.
Their case are different.
The others are Sanskrit.
First and second you can take
Sanskrit.
First and second is Sanskrit.
Sanskrit.
That shall I submit to?
Yes.
Before they start, I am in the PET matter. Can it be taken up tomorrow, my lord? Or tomorrow, PET matter tomorrow. It is also equal. Selected.
Tomorrow, all right?
No, that's Sanskrit, that's Sanskrit. That PET matter, the segregated matter.
Segregated matter.
That is the PET. That is a small matter can be disposed of. But tomorrow, if not today.
After seeing this, then we can take a pure matter.
No, this
will start today. Let them start.
It has no nexus, I think. If somebody will argue, so if somebody will try to take up these two batch of cases, then I have nothing to say. But the PET can be disposed of independently.
We can take up Sanskrit.
Sanskrit may take up today, so therefore I am submitting tomorrow. Is concerned.
You just started. Let us see. You keep it. Even today. Also with this only we can. It will be on the same day whenever this is posted that way.
Oh, all right.
In second item,
Second item is the lead case.
It is the
second item is the lead case.
Second item is the lead.
16242 by 2020.
14501.
16242.
Yes. 16242.
Second item.
Avinash Mishra.
Avinash Mishra.
And my lord, another.
In that petition, I am the petitioner. My amendment petition, but IA number 20213 of 25 is pending.
What is that amendment?
Only to insert the, apart from my other rules, only ground to for seeking direction to for a preliminary exam, which has not been done as admitted.
That we have filed our objections to that.
There is more than
that we have filed our objection. The objection may be
more than 5 times is
File objection.
5 times.
The state has filed, so also we, the private parties who have appeared in that final exam, have also filed an objection because this comes after that other order. So they are basically, it's a ground of fence sitter.
Objection which is my friend has not been solved. Okay.
No, sir, please. Sir.
Not answered, not so.
But what
the objection filed by the commission has been solved.
Madam.
Yes.
What I suggest is, let us allow that application. And or we can take up that application as additional pleadings only, so that again amending and other things, it will go beyond January. That will not serve anybody's purpose. Yes. So as it is, if you all agree, the application along matter itself can be taken up. The application can be taken up along with the main matter itself.
Yes.
That everybody's understanding.
Yes.
That the application also will be heard along with that.
Yes.
But there is one risk.
That can.
Supreme Court says where amendment is sought for, court has to pass an order on that. Permit amendment of the pleadings so that parties will only thereafter court should take up the main matter is the version. But all of you agree. I can make an exception saying that the application will be treated as part of the petition itself.
Now the difficulty will be, he want to change the prayer of the petition. If the prayer is now want to make, if that will be argued, then it will be difficult for us to answer. That may not be taken into consideration. Ignoring that amendment petition will also make
it. Is the formal in nature.
One way to it. It's been kept as an additional pleading there. We also file an affidavit replying to that additional pleading. So because whole, and so that our reply on merit to that amendment is also on record and everything is heard. That's just because the main approach is that if something new is coming.
That will change the very structure of the petition.
Yes, exactly. Change the natural character of the case.
Madam, can I interrupt your lordship, madam? Well, I am also an applicant with a writ petition bearing number 31675 of 2020. What the amendment, what is being suggested in the lead case, the so-called lead case in the WPC 16242 of 2025, that is also there as an impugned action in my case with prayer properly structured, where your lordship on the day one issued notice to the state panel council asking him to file counter, fixing the date originally to 27th of November. Till today, my lord, there is no counter affidavit filed. So even if your lordship allows that IA, which he has filed by way of to bring certain facts by way of amendment is allowed, That is only make the same case, the said case at par with my case, which is already there. So there is no meaning.
In your case, already such a prayer is there. You had no such prayer earlier. Now you have made the application. And seeking permission of the court is one thing. But that prayer is already made. What Madam Pami says appears to be sensible. Yeah, since that prayer is already there in one of the petitions.
The writ application has been filed recently after all these things, when this matter was argued, thereafter this was filed.
But it is.
But again I have to give reply, it will take.
Then there will be no end to all this.
Yes. No, take up that matter. Mr. Dutta is suggesting that maybe.
Your Lordship issued notice in my matter, such an understanding was also given by my Lord senior counsel appearing from the department, that we will be filing the counter. That is why the short date was given. But my Lord,
if I say like this, the prayer which now he wants to introduce would not much come in the way.
Yes.
Since such a prayer is already made in one of the petitions.
Yes.
So that time can be saved.
Yes. And your
Our argument is that
and it is a
major objection, whether to his amendment or to Mr. Mahanti's case, is this, that both of them somehow lack the locus and they have not come with clean hands before your Lordships. So if that is also taken as a preliminary ground and we succeed in showing that
the petitions will go.
Our objection also to this prayer is basically that.
Your objection to amendment may not fail. You might have taken that. But generally, such contentions are taken to ensure that the petitions are dismissed in limine.
Yes.
Without much discussion.
Yes, your Lordship.
But if that contention will remain, whether I allow that application or not.
Yes, your Lordship. So, in fact, that might be the first thing which needs to be adjudicated to see that whether the court will at all be interested to get into litigation.
Whether the court will take up the matter or not.
Yes, your Lordship, because it's a court of equity. Those three principles always will stay.
My Lord, so far as all these matters are concerned, this is squarely covered by your Lordship's judgment.
Yes.
Rendered in the case of teacher, where, my Lord, the advertisement condition was violated by not holding that preliminary examination, even if the valid candidatures were more than 5.
Ratio was available.
Yes. So same thing has been asserted over here. And my Lord, the counter affidavit filed by the commission in the other case reveals on affidavit that in the case of Sanskrit teacher as well as PT, the total valid applications were more than 5 times of the advertised vacancy, but still they decided to not to hold the preliminary examination by a single order, which your Lordships have deprecated. In the single order, they are both for Hindi, Sanskrit and PT. The commission decided to hold the preliminary examination, violating the condition.
There is a difference between that case and present case.
We have two important judgments of the Supreme Court. That your Lordships, the judgment in the Hindi matter comes at the behest of a petitioner who was vigilant about his right, comes immediately to the court.
Exactly.
This petitioner here, his petitioner, sat through the hearing. Now when the judgment comes and finally everything is over, he comes to the court. Your Lordships, that judgment is confined to Hindi. Even a latecomer cannot say that, you give me the same, we have a judgment to that effect. And as far as Mr. Mahanti's client is concerned, he has only come yesterday.
After knowing the fact that he has not been selected.
No, selected candidate.
He comes when there was a complete notification showing that we are not going to hold the preliminary exam. He goes, participates in that examination, final examination. Document verification notice comes up. He still does not come to the court. He comes after that judgment is declared. So there are many locus points. I think that unless that is not crossed over, they cannot come up parity with that Hindi judgment. That petitioner was a vigilant petitioner.
My
So
case
that-
is not.
We have
My-
fence-sitters. And he also makes.
Not late comer, not late comer. We had at the same time Hindi, in Hindu case.
We applied at.
I'm calling this matter tomorrow.
Lordships.
From tomorrow we start.
Yes, ma'am.
Tomorrow, your lordships.
How many cases are posted to Malan? Only this matter at 2 o'clock. Only this matter.
Lordship, three matters similar. Same issue. They have not conducted three, item number 3.
We'll hear it tomorrow, na?
Your Lordship, all the matter come. All the matters may come.
All these matters
may come tomorrow. That each matter which may learn clear. This is item 3. I am for the. Yes. As for the petition. The last was mentioned that it shall be said, it may be segregated. No, my Lord.
No, segregated for tomorrow.
but called along.
Tomorrow, yes.
Let it come this matter. Yes, but tomorrow only.
Tomorrow it will come.
In that PET matter.
16242 matter.
How is it? The PET matter we have filed our counter. PET matter we have filed our counter, but that has not been tagged with the file. Don't call it.
Registry to put the count.
My lord, in WPC, in WPC,
Give copies.
Yes.
Counter copies. Tomorrow I will not, you can't say that copy is not sorted.
I will solve.
my lord, let file the counter which your lordship directed in 31675.
How can I direct? I can only say if you want to file. Otherwise not. Okay. She may argue without use of your counter. Yes.
Okay, thank you. I have matter for 57. It is covered by your lordship.
57.
Challenging the consent charge by the GA department for conversion.
Pays for the, where is your friend? Where is your friend?
Government shall receive.
Not covered. Not covered.
It is item 60.
Pardon to make a mention, my lord. Item 16 only. The petitioner has retired since 2013, my lord. He has not got any pension, my lord. So can it be any day this week, my lord?
This week.
Item 60. Item 60 pension case matter. Item 60 pension case. Item 60 matter. Item 60.
What is that matter?
51 dollars का matter similar matter or she has exposed to one matter. So let's say next week is passed.
That item
Next week after next week.
that item 57 may be taken up tomorrow. It is covered by your lordship's judgment. That I will satisfy your
You are
lordship.
saying it is not.
No, it is covered because the concession fee, they are charging the concession fee in addition to the conversion fee. To make it free.
Next week.
Yes, next.